Stop that.
So something at the end, that's something. You know, it ran away. So everybody knows that.
In my
She just kind of said it.
I don't think I do today, but I still think it's okay
But
to
if we
set
get
a
into that
time.
later, I thought nobody cares.
Yeah, yeah,
It's been so long, it's just like, let's just get it over with.
yeah,
Yeah.
No.
yeah.
We should all decide, well, just retire your back, so it's-
Yeah, no, I mean, if you set that time and say it's 10, 20, so they kind of-
It's all right.
Yeah.
Then we keep going.
Then we keep
Yeah.
Yeah.
If we're just gonna-
Yeah, no, yeah, I keep running. Yeah, Aaliyah's gonna work on it. So I said. Is IT good? Okay.
Doing well.
So if IT's good, we're gonna open up our meeting, please, so everybody has to be quiet, it's recorded.
And then close it out. Yeah.
Okay, go ahead. Yeah, we'll call it to order. I mean, I don't think we have to approve the, well, let's approve the agenda.
I make a motion, we approve the agenda.
Second it.
All those in favor say aye.
Aye.
The minutes of the 15th. Let's just.
I'll move to approve them.
I'll second it.
Any questions or corrections? Hearing none, all those in favor say aye. Opposed, say, all right. Oh, yeah, go ahead. Yeah.
Good morning, everyone. Welcome back. Just a quick reminder on process and procedure. Today, I believe we have 11 more public comments that are on the slate to give some evidence and testimony today. And so only those folks are going to be able to provide public comment. After that, the applicant will have an option to respond to any of the concerns that were raised or questions. The committee can also engage and ask questions. Just in case for those of you who maybe were not here the first time, this is not an opportunity to have the audience ask questions of the folks who are giving public comment. If you are providing public comment today and you have a question for the applicant, it's not a time to engage with the applicant, ask the committee, and if they so choose, they can ask the applicant when that time happens. We're hoping that we can get through everything today. So as you go through and provide your public comment, rather than repeating things, if you've pretty much gotten through everything, we're not going to cut you off as long as you're providing new information and relevant information. But if it gets circular and repetitive, I think the chair might move it along just so everybody has that opportunity today. We do have the other room set up, but I don't believe anyone is in it. We are going to leave it open for another 10 minutes. But if we don't need that as an overflow room, we're going to go ahead and close that off just so there isn't any confusion. Any questions from the committee of me before I take a seat? Did we get started?
No, we should be. We'll probably take a break. We'll kind of time it, see when we take breaks and lunch and stuff.
Okay.
We'll go from there.
Thank you.
All right, Mr.
Chair. And that the next up on the public hearing is Nick Vivian, provide comment. So he's number 9 on our list.
Number 8 crossed out.
Number 8 was Bob
I'm
Wright.
sorry.
Nick, do you have an extra copy of what you handed out?
I think it.
And the handout that was provided from Nick, that of the PowerPoint, that will be exhibit 69 to the file.
Thank you, Mr. Chairman, members of the committee. My name is Nick Vivian. I'm the attorney presenting on behalf of Forest this morning. First, let me say thank you for the time that you're taking to examine this application in detail. Certainly appreciate that. I want to say before we begin, I appreciate and certainly respect the work that Mr. Hillquist does, appreciate the work that your corporation counsel does as well. By way of background, I'm a managing shareholder with the Eckberg Lammers Law Firm in Hudson. I've been practicing in the area of land use and municipal law for 20 years. The city attorney for New Richmond and Hudson, a number of towns in St. Croix and Burnett counties. I also happen to be corporate counsel for developers like the applicant in complex and sensitive projects proposed in Western Wisconsin. In addition, I provide counsel to advocacy groups opposing land uses where there's a perceived overreach beyond comprehensive plans and zoning codes. And I'll tell you, conditional uses are at the core of what I do. They're not easy to get, and the process is intended not to be an easy process. It's intended to be a rigorous process. What I want to say before we start is appreciate the process that you've run, the folks that are involved. This isn't about who's right or who's wrong or who's good or who's bad. This is about the legal standards in Wisconsin. It's about the materials that have been presented by the applicant. The applicant bears the burden of satisfying your requirements. And it's about your opportunity to match the facts and the documents that are presented with those legal standards as you work through this process. Having seen all sides of this issue, complicated, right? Act 67 is not easy to work through. Every situation is different, factual. And so you've got to take what's been provided and again, apply that against those legal standards. The purpose of my testimony this morning is pretty simple. You've heard from neighbors and community members who are opposed to the proposed use. They've told you why you should deny the proposed use. My testimony is intended to provide the basis of why you must deny the proposed conditional use permit under Wisconsin law. As indicated in the application seeks to authorize certain property located in the town of Osceola to be operated as an active quarry with activity including drilling, blasting, crushing, screening, water processing, and rail or truck loading operating from 7 a.m. to 6 p.m. on weekdays from March 15th, November 15th, and potential rail car loading 24 hours a day. Although as we heard last time, we don't know a whole lot about what the potential for rail car loading is in the future. There was a lot of discussion last time about the prior application that was considered by the Land Information Committee, the Kramer Mining and Materials application. The landowners in that application were relatively the same. And the Kramer Mining application was rejected by the Land Information Committee, and the renewal of the same application now by this applicant must be similarly rejected. In that application, and we're going to talk a lot about it because it's important, because this application relies on the information that was submitted as a part of that application. So even though that application was submitted more than 10 years ago, the information, the application that's before you today is heavily reliant on what was submitted almost 15 years ago. Based on those studies, that information, and what was submitted then the application was denied. Not only was the application denied, it was appealed. We'll talk about that appeal in a second. It went to the circuit court. A judge looked at everything that was on record, and the judge determined that there was substantial evidence to support the Land Information Committee's decision to deny that application. When we look back to the application denial findings, there are a handful that I want to focus on because I think they're particularly relevant to this application. The first is number 3, which is a recitation of your zoning code, which says such approval shall be consistent with the general purpose and intent of this ordinance and shall be based upon such evidence as may be presented at a public hearing tending to show the desirability or undesirability of specific proposed locations for the proposed use from the standpoint of the public interest. Because of such factors as without limitation, smoke, dust, noxious and toxic gases and odors, noise, vibrations from operation of heavy equipment, heavy vehicular traffic, and increased traffic. So in the last application, they looked at all those factors and they found that the applicant didn't meet its burden. Finding number 4 from the Land Information Committee provides that the purpose of the comprehensive land use ordinance is to promote the public health, safety, morals, and general welfare of Polk County. That holds true today. And number 5 were the factual findings, the environmental findings. The proposed quarry is inconsistent with the general purpose and intent of the comprehensive land use ordinance and contrary to the public interest for a variety of reasons. Number 1, the evidence that there would be increased traffic in the area disrupting the flow of emergency services was persuasive and not adequately addressed by the applicant. Haven't heard anything from the applicant here. The quarry would cause noise issues from blasting and normal operations of the crusher, other heavy equipment, and the increased traffic. The noise reduction efforts proposed by the applicant would not sufficiently reduce the harmful effects of the cumulative noise factors. The vibrations could cause structural damage to homes and other structures in the area as evidenced by the report that was submitted and testimony, which is part of the record here. Water quality for residents could be negatively impacted by the proposed use, by the proposed quarry. And then 6, the 6th finding, back from the Kramer application. Having reviewed all of the evidence and the ordinance, taking the evidence, the documents, everything that was submitted and matching it against the county's ordinance. It is determined that operating the proposed quarry at the proposed site would have a negative impact on the health, safety, and welfare of those who live, work, and play in Polk County. So the Land Information Committee made its decision, and then the applicant, within its rights, within Wisconsin law, appealed that decision to the circuit court. And Judge Black out of St. Croix County heard the case. And he noted in his decision that the Land Information Committee looked at the purpose and the intent of the comprehensive land use ordinance and determined that based on the evidence, the proposed quarry was not in line with such purpose and intent. Again, we look at the ordinance, we look at the purpose, the intent, and the evidence, and the proposed quarry was not in line with the purpose or the intent of the ordinance. Judge Black went on to say that the committee clearly laid out its reasons, the reasons I just read, for coming to that conclusion, and nothing in the record indicated that a reasonable view of the evidence would not have led to the same conclusion. He went on to say, there was substantial evidence, and you're going to hear that term again. You heard it yesterday in considering the testimony regarding Act 67. There was substantial evidence to support the committee's decision. and it should be upheld. So the question now with the Blue Rock application is what's changed? Jason or staff did a really nice job of presenting you with a document that lays side by side the Kramer application with the proposed application. So what's changed? I note 4 things on that whole list, that 2-page document that have changed. 1 is depth. 2, there's no proposed reclamation plan. 3, the quantity of material is now identified as being market driven. Market driven. What does that mean? And number 4 is traffic. They're proposing fewer trips just by a promise that they're making to the county. As I indicated when I started, it's your responsibility to focus on what's been provided. And here's what you have in the file, again, relying on the Kramer application. You have an archaeological report that was completed in 2005. You have a wetland delineation that was completed in 2004. You have a hydrologic and a hydrogeologic assessment that was completed in 2008. You have vertical electrical surrounding study that was completed in 2008 with inconclusive results. You have a traffic study that was completed in 2006. You have a biological study that was completed in 2004. We sit here in 2022, and this applicant is relying on studies that were completed in 2005, 2004, 2008, 2006, 2004. I do a lot of development work throughout Western Wisconsin. Started in 2003. Western Wisconsin has significantly changed since 2003. However, when you look at the Osceola, Dresser, St. Croix Falls corridor, it has dramatically changed. And I heard testimony the last time around about transportation from Osceola, Dresser, up to St. Croix Falls. There's no community that's changed more than St. Croix Falls. When you look at Menards, when you look at Walmart, when you look at all the development up on Highway 8. Surely during that time, traffic patterns have changed. Surely there have been many, many changes in the communities that bear study, that bear consideration, and at least a basic updating of the reports that were submitted from 2004 to 2008. What struck me though, as I listened to the testimony that you took both from the public and from the applicant, is what wasn't provided at all. And there were questions from the committee on these points. No scale drawings have been provided. No traffic study with post-2006 analysis has been provided. There's not been a stormwater plan provided. There's not been an erosion control plan provided. There's not been a reclamation plan provided. There's not been vibration testing study. There's not been sound study updated related to this specific proposed use. There's not an access plan for rail crossing. Based on the conversation that the committee had with the applicant, there's not even a proposal for how rail might be used in the future. Yet at the same time, the applicant is saying, provide us with a permit that gives us the right to operate the quarry. As I stand here today, I can affirmatively tell this committee that the Land Information Committee knew more about the Kramer application and the Kramer proposed use than does this committee know about the Blue Rock proposed use. The Kramer application, with all of its studies and all the information provided and all the input from the town and all the input from the residents, was denied and upheld by a judge from outside of this county. And here we sit today with an application that has far less support than what the Land Information Committee had before it, with its decision being upheld by the court. Now I'll take us back to the zoning code because Judge Black focused on the purpose and the intent of the zoning code. Did the Land Information Committee look at the zoning code? Did it make those considerations? Did it match the evidence with your code? And here are just some relevant considerations in your zoning code. The express purpose and intent of your zoning code, chapter 42, is to promote the public health, safety, and other aspects of general welfare. For purposes of this chapter, this includes promoting planned and orderly land use development, protecting property values and property tax base, advancing uses of land in accordance with character and suitability, aiding in the protection of groundwater and surface water, preserving and enhancing the county's rural characteristics, protecting vegetative shore cover, promoting safety and efficiencies in the county's road transportation system. When we look to conditional use permits, there are specific requirements in the code for conditional use permits. And the standards that you are required to evaluate include the following: the maintenance of safe and healthful conditions, creation or increase of smoke, dust, noxious and toxic gases and odors, noise or vibrations from heavy equipment, the erosion potential of the site based upon degree and direction of slope, soil type, and vegetative cover, heavy vehicular traffic and increased traffic, the need for the proposed use, and its compatibility with uses on adjacent land. That's your job. That's what you're required to evaluate what's been provided against your code, against chapter 42. Now, Mr. Hellquist argues eloquently that the law says that if they agree to come in and abide by whatever reasonable conditions you put on this use, that you are required to approve the conditional use permit. That's not the case. That's not what the law says. But let's walk through the conditions that they're proposing. The conditions that they're proposing are 16-foot berms to the north is needed for noise mitigation, as needed. We don't have an updated sound study, so we don't know what's needed, but they're saying, trust us, we'll do what's needed. A water settling basin to be constructed for runoff and processing water. Limited hours of operation, seasonal operation, reclamation plans to be provided at the appropriate time. No greater than 55 decibel sounds at any residence during the daytime. I can tell you as a municipal attorney that one of the most difficult ordinances to enforce for a community is its noise ordinance. Because when you get that complaint and the sheriff shows up with its decibel meter, noise isn't there anymore. So how do you enforce it? They're promising to keep the noise down, but it's incredibly difficult to enforce that particular provision. And then quarry depth limitations, which they say will ultimately mitigate against groundwater issues. Now the question is, are there conditions based on the substantial evidence that they've provided? I would ask you, how do we know? Because the reality is that they're relying on the Kramer information that was submitted back in the middle of the 2000s. That hasn't been updated. That hasn't been brought forward. Now, I'm 100% certain that in his rebuttal, Mr. Hellquist will say, Well, you can require as conditions that we submit all those studies and that we update those reports and that your staff look at it and check the box to say that we've done this stuff. I would submit to you, that's not good enough. This public hearing is based upon the public's right to know what's in those studies. You can't reasonably make a decision about their plan without having studies that have at least been updated in the last couple of years, let alone the last 15 years. It's impossible. It is a legal impossibility. And I submit to you that there is no way that we can know whether any of their conditions are the least bit reasonable because they have not supplied the studies, the information, the factual background to give the public or this committee the opportunity to evaluate whether their conditions are right or whether they're wrong. The other thing we know, as I said, is that this corridor has changed dramatically. So how is it that we should rely on traffic study numbers, for example, from 2006, when Quick Trip wasn't there and Menards wasn't there and the Highway 8 corridor wasn't developed? How do they know which direction trucks are going to go? How do they know what the impacts are going to be on your roads? Not their roads, your roads that you're going to have to take care of. This isn't, it's not a check the box matter. It's not a, yeah, we'll do it. If you tell us to update those studies, we'll do it. That's not what we're talking about. That's not acceptable. It's not acceptable. And it doesn't carry the burden that an applicant has to convince you or to even provide substantial evidence that you should approve an application. Again, I come back to it and reiterate it. No scale drawings, no updated traffic study, stormwater plan, no erosion control, no reclamation, or it's to be provided at a future date. No updated vibration testing, no updated sound study, no access plan for rail, no future rail infrastructure plan. How do we know? We have to guess. And if you have to guess, there is not substantial evidence in the application or in the record to approve the conditional use permit. Now the elephant in the room, Act 67. Mr. Hellquist and I have had the opportunity to argue Act 67 in Burnett County on different matters. And if you're on the other side of the table, of course, you take the position that Act 67 says a county has no authority. If we as a developer come to the table and say, yes, we'll do whatever you tell us, you lack the authority, and that's simply not the case. The county's decision, your decision, the law says it's very clear. Your decision has to be made based on substantial evidence. The applicant must demonstrate that the application and all requirements and conditions established by the county relating to the conditional use permit are supported by substantial evidence. The county's decision to approve or deny the permit has to be supported by substantial evidence. Conditional use permits by themselves are exceptions to the uses that you permit in your zoning district. They're uses that the local municipality or that the county has said they're okay, provided that we can put conditions on those uses to protect the health, safety, and general welfare of the community as it ties back to your zoning code. And if an applicant, any applicant, not just this applicant, but any applicant, can't meet a requirement of the zoning code, you cannot legally approve that conditional use permit. So substantial evidence, what does it mean? We can have our own theories as to what it is, but the law provides a definition. The law says, under Wisconsin statute 59.69, substantial evidence means facts and information other than merely personal preferences or speculation directly pertaining to the requirements and conditions an applicant must meet to obtain a conditional use permit, and that reasonable persons would accept in support of a conclusion. How the legislature defines facts and information, not personal preferences and not speculation, which means not opinion, not I think so, not I'd like you to draw an inference, or I'm asking you to guess in my favor. That's not substantial evidence. Not only that, the legislature included the reasonable person test. That reasonable persons would accept in support of the conclusion. So is it reasonable for the applicant to come forward with a proposed use, but without the support? With the proposed use, but without updating reports for 15 years? Is that reasonable? I would submit that it's not. And I would submit that you can't get to the threshold where you have substantial evidence to approve this particular application. So here's what I think you ought to do in terms of findings, and I've provided them in the PowerPoint. I think the proposed findings ought to include the following. Number one, the application is inadequate because it fails to provide current facts and information required to obtain a conditional use permit under Wisconsin law. Number two, the application lacks the inclusion of updated studies to support the proposed use of the property based on the current condition of the Osceola, Dresser, St. Croix Falls corridor. Number three, the proposed use is inconsistent with the purpose and intent of Chapter 42 of the Polk County zoning ordinance. Number four, the proposed use fails to adequately address the required conditional use standards detailed in section 42-149C of the Polk County zoning ordinance. Number five, the applicant has failed to establish by substantial evidence as defined by Wisconsin law that the health, safety, and welfare of the surrounding community can be protected by reasonable conditions. Next, the proposed quarry will create increased traffic on local roads, disrupting the flow of emergency services, and isn't adequately addressed by the applicant. We know there's going to be increased traffic. That's a certainty. Next, the quarry will cause noise issues from blasting and normal operations of the crusher, other heavy equipment, and the increased traffic. Blasting and operational noise from the crusher will be real during the hours of operation. We know that from the prior studies. Even without updating the study, that's what you have on record. Next, the noise reduction efforts proposed by the applicant would not sufficiently reduce the harmful effects of the cumulative noise factors. They haven't even provided us with any additional noise mitigation efforts other than a berm and a promise that will keep the noise down. That's not sufficient. Next, the vibrations could cause structural damage to homes and other structures in the area. This has not changed. The finding made in 2009, 2010, and there's been nothing provided in this application that says otherwise. And finally, water quality for residents could be negatively impacted by the proposed quarry. That also has not changed. Same thing, was a finding made to then. There's been nothing provided now that would change that particular finding. To conclude, and I appreciate your time and consideration in listening to this presentation, the substantial evidence known to the public as submitted by the applicant clearly and unequivocally demonstrates that the applicant has failed to satisfy all requirements and conditions established and required to obtain a conditional use permit in Polk County, Wisconsin. The committee cannot make findings based on substantial evidence not defined by me, not defined by Mr. Helquist, but defined by the Wisconsin legislature that would support the approval of the application. Applying the strict requirements of Act 67, the application must be rejected by this committee. The proposed use will have significant negative impacts in the form of noise, vibration, traffic, water quality, property values, and there are no conditions based on what's been submitted by the applicant. There are no conditions that you can impose today that would adequately be placed on the proposed use, which would appropriately mitigate these impacts or even address what we don't know because those studies haven't been updated in the last 15 years. Thank you for your time.
Thank you. Who's next?
Right, next up, Mr. Chair, is some comments that were submitted by Aaron Degerstrom. And the next one after Aaron is Sonia Degerstrom. And just so everybody is aware, they submitted some supporting documentation along with their comments. One is a letter from the Well Riley firm to Steve Stroshane, which is the chairman of the town of Osceola, dated December 5th, 2008. And it has to do with the proposed mining ordinance. So the next one that they submitted is town of Osceola public hearing minutes from Thursday, August 25th, 2016. That was on the Haas pit when that was done. And the town minutes from the normal Board of Supervisors meeting dated September 6, 2016. So those are the minutes. I'll read the comments, and then if there's any questions, they're quite lengthy. So both Aaron and Sonia were not able to attend today, so that's why I'm reading their comments for you. I received the comments this morning via email.
I guess I have a question. Were these not comments that were prepared at that hearing, or are they, I'm sorry, when are they, if they're not allowed to, if they're not here?
They were on the list of the
Okay.
11.
Yep. To speak.
Yeah, okay. And was this something they had prepared for that hearing?
I believe they were here in person at that
Okay.
hearing.
All right. I just wanted to clarify that. Thank you.
Good. All right, so Aaron's address is 983 Southview Lane, Dresser, Wisconsin, 54009, town of Osceola. Proposed quarry access at County Road F and M. According to the pictures presented at the previous hearing, are located in areas with significant visual impairments to both semi-trucks and passenger vehicles. With the current sight lines that exist at both of the proposed accesses, I'm concerned that there would be a significant increase in vehicle accidents involving semi-trucks. A fully loaded truck takes 4 to 5 times longer to get up to highway speed than a passenger car. Vehicles traveling on these roads at the posted speed limit will not have time to see semi-trucks entering the roadway. This is not something that should be an afterthought. This will only lead to more needless accidents or worse. Many other concerns have been shared about the proposed quarry that I agree with: noise, water quality, property values, quality of life. For all of these reasons, this quarry is not compatible with this community. Thank you, Aaron Dagerstrom. And that was the only comment, and that was speaker number 10. Okay, so just for the record to be straight, we'll make that exhibit 69.
That was Nick's 69.
Oh, sorry, 70.
All right.
Okay. With that, I'd like to go into Sonia's comments. Same address, 983 Southview Lane, Dresser, Wisconsin. This one's a little bit longer. My husband and I moved here to start our family 17 years ago. We chose this small town because of the community, schools, housing opportunities, and community activities. I am a teacher at a local school and have served on boards, volunteered countless hours in the community, and coached high school sports. My husband has also served on boards, coached community hockey and soccer, and served other community as a volunteer. We have been active in our community along with our neighbors in Trollview Estates and Lotus Lake Estates, along with our surrounding neighbors. We are involved community members who make this town great and a valuable and attractive place to live. That value does not have a price tag and is what truly makes a community. We are not the mob that the applicant has called us. We are homeowners, community members who have spoken in volume at the Town of Osceola meetings. This is because we are protective of our homes and community. We actually truly know what it means to live by a rock quarry because we do. We are well-educated and experienced. Who wants that again, especially located between two existing housing developments? We know the risk for our quality of life, families, and homes. It's not compatible, and the community has spoken. We have all experienced stress, the unknowns, anxiety, unhealthy, and unpleasant living conditions in the past 2 years. No one needs more of that. This takes a toll on kids and families in the community and affects our grade. The impact of this quarry over time will change the quality of this community. It will drive people out and not in. I urge you to listen to your community for both current and future residents. We have invested in our homes and in the people. Please don't affect our homes, quality of life, and the desire to live in our beautiful town. Now that I have shared my heart and overall concerns, please hear my detailed reasons and evidence as to why the proposed rock quarry is not compatible. There are ongoing questions and concerns that the applicant does not address, thus continuing to prove lack of compatibility. The applicants are proposing mining the ridge that divides two watersheds. This ridge is near the north part of their proposed operation. Just north of the watershed divide is an unnamed stream that flows from east to west. Current rain lands on the watershed divide and flows one side or the other, eventually running off the hard surface into the ground and flowing into the groundwater. If a pit is established where the watershed divide once existed, water will no longer be flowing off the rock and into the groundwater. The quality of groundwater is going to one or both of the watersheds on either side of the divide will be reduced. This is a concern to neighboring landowners that rely on the recharge for their private well water. Reclamation requires that surface and groundwater flows are restored. In addition, diverting this water from streams requires a Chapter 30 permit. Chapter 30 of state statutes regulates impacts to water. This permit is required whether the stream is navigable or not, and requires applicants to get consent from all riparian owners. Riparian owners are those that own property adjacent to the stream. Where is Blue Rock at with this process? The county's reclamation ordinance states that non-metallic mining sites shall be reclaimed in a manner that does not cause Number one, a permanent lowering of the water table that results in adverse effects on surface waters. Or number two, a significant reduction in the quantity of groundwater. Again, currently, water runs off the rock into the ground. Depending on where the rain lands, it may run off into one watershed or the other. When done, a big hole in the ground will retain water, reducing available groundwater to neighboring properties that rely on that recharge. Here's a little clarification on the surrounding mining operations. To clarify and emphasize prior testimony, gravel and sand pits are not comparable to hard rock quarries, and one of the nearby gravel pits referenced in the application is no longer operating. The Haas pit is permitted for hauling only. Technically, they are permitted to crush, but the intent for them was to crush and recycle material that was in the pit in 2016 so that they can haul out and clean up the pit to complete the reclamation process. Essentially, all operations are completed except for hauling and reclamation. The county may have more up-to-date information regarding the reclamation status of that pit. I'd like to revisit the noise element briefly. As you heard in an earlier testimony, the noise limits proposed by the applicant seem a bit deceiving. You heard that the noise emitted from this quarry will be equivalent to a dishwasher. Doesn't this seem preposterous? Have you ever heard a dishwasher manufacturer claim that their dishwasher is as quiet as a rock quarry? This doesn't add up. Something is missing from the applicant's noise component, as was pointed out in Mike Wallace's testimony. Hopefully you all had a chance to digest that testimony given by Mr. Wallace. 55 decibels as referenced in the application is seemingly much different than 55 decibels. It's doubtful the applicant will recommend the condition that the max decibel level at everyone's property line will be at 55 decibels because it's impossible for a blasting and crushing quarry with so little buffer to meet that requirement. It's much easier to state that they will be under the certain decibel level a percentage of the time. How much will they be over the 55 limit the rest of the time? We can only speculate, but we do know that blasting could be above 100 decibels and loading rails cars is noisy, that operators are required to wear double hearing protection. Regarding vibrations, it's doubtful that the applicant will recommend a condition that requires no vibrations in neighboring houses. Why? Because it's simply not possible for them to meet the condition. They may argue that such a condition doesn't meet the reasonable test. Really, is it reasonable to be allowed to make your neighbors' houses shake on a regular basis? As a homeowner, is it unreasonable for me to not want my neighbor to violate my privacy by making the one place that I have complete control over shake and vibrate? Dresser Trap Rock is permitted to operate in the town of Osceola. If we compare this proposed quarry to Dresser Trap Rock, we will find that the town property owners are buffered from Dresser Trap Rock's operation in the town of Osceola by at least a half a mile. It has been said that the rock is where it is. We can't change that. True, but clearly the Blue Rock proposal is in the wrong place and the wrong time. What can be and should be done is this application should be denied like it was last time. It has been mentioned the town of Osceola attempts to address noise, vibrations, and dust in their mining ordinance. This doesn't preclude the county from independently evaluating and considering those effects on the community. This committee shouldn't assume that the town's requirements are effective enough for this specific application. Also, there's no guarantee with the volatility at the town level that their ordinance won't get changed. It's easy to meet the requirements that don't exist anymore. In addition, the applicant may challenge the town ordinance. This isn't just a conspiracy theory. The last applicant, represented by the same firm as the current applicant, argued that the town ordinance shouldn't apply to them, claiming that the town's ordinance is a zoning ordinance. They also argued that registering the properties exempts them from having to comply with the town's ordinance. If that's true, then perhaps the applicant would agree that this hearing is the correct forum to consider the effects of noise, dust, and vibration on the health, safety, and welfare of the community, and that those impacts can be mitigated in this case. With no mitigation options to prevent people's houses from vibrating and no mitigation options to reduce the negative impacts of the noise on the community, the only option for this committee is to deny this permit. I greatly appreciate your time and service. That was Sonia Degerstrom and family. So that's what we've got. So any questions on those two comments?
No, go ahead.
Okay, so the next one up is Mike Banners.
Well, my name is Mike Van Epson. I live at 991 210th Street, Dresser, Wisconsin. And the property that I have borders the proposed Blue Rock Quarry. So we are direct neighbors. I've lived in this community for 33 years. I moved here from the cities in order to enjoy the peace and quiet and to do the hobbies that I enjoy, like gardening, beekeeping, you know, all things outdoors. And so we all know that a rock crusher is creates a deafening sound. And if you think that a person is going to be able to go out and enjoy an afternoon with your children, or to go out and do your gardening and things of that nature that you really enjoy, and that's why you moved here, those things are going to come to an end. And how can I say that with such passion? As was mentioned, that there was a quarry right across from Lotus Lake where they crushed rock for several months. You cannot hide or buffer that sound. It's continuous, it's deafening, and it will definitely affect your mental core. It just doesn't go away. It's nonstop. So it was mentioned that we need to work together, and that's very true. But when a whole entire community has to give up peace and quiet, have additional burdens based on taxes and road conditions, and all of these things were mentioned before, and it's only for the benefit of a handful of people. That's not working together. That's not fair. So this has not been a good fit. Every time that this proposal has come before the village of Dresser, town of Osceola, and everywhere else, it's been denied. So I asked that the committee here, follow suit with something that doesn't fit. It's like trying to pound a square peg into a round hole. It didn't fit before. It doesn't fit today. It won't fit in the future. So I ask that this proposal be denied based on a lot of factual information that's very substantial. So thank you.
Thank you.
Next up is Tony Avenues.
Give it to you.
Okay.
I want to block you. I'm gonna move this.
You're good.
This is a microphone.
No, that's a recorder. So
Keep it on the, do I need to be close to it?
fix it up pretty good.
I'm gonna move over. I didn't want to block
No, you're fine.
Good morning, committee members, applicants, county staff, my friends, and a few other folks that I haven't listed. My name is Tony Havranek. I live at 848 217th Street in Osceola. I'm about 5,000 feet straight southeast of the proposed quarry site. I have a Bachelor of Science in Broad Area Agriculture with an emphasis on natural resources. I've got about 21 years of experience in the natural resources field. Kind of thought about today, reminded me a little bit of a funeral. A lot of people here that I'm glad to see, a few maybe I'm not, and here for not a great reason. I'm here to request the denial of the conditional use permit, which is dated January 2022, and which is the subject of this hearing. I swear I didn't copy what you had to say, but you're going to hear some very similar things, just not as eloquently as what you heard before. I think it's actually a relatively easy decision for you as committee members. The application should be denied based on the same issues and the same rationale that you used for denying the application previously, which are the negative impacts to the environment and subsequently the residents within the town of Osceola from the quarry, which are still posed by this application, and eventual expansion of the quarry as stated in the application. If anything, those concerns have been amplified since 2009, as the land, water, and air resources we value and rely upon are even more utilized and strained in increased use in the last 13 years since the last application. The proposed project of the salt quarry that utilizes blasting and other extraction techniques, which is proposed to expand in size and scope after it is permitted, inherently imposes a series of hazards, environmental degradation, and human health risks, even with proposed changes to the size, scope, and operational activities, which are not specified and for which the application briefly discusses in sweeping generalities and which are not well thought out, and which also are not outweighed by the narrow financial benefit to the applicants. A few of those examples are, is it rail or is it truck? How much? Dust is controlled using state-of-the-art methodologies. What are those? Blobs on a map that appear to shift, have little rationale for the proposed location, or are not accessible to existing rail right-of-ways. Potential access to County Highway M to the west of the site poses significant vehicular safety issues due to the limited line of sight from road curves. Therefore, the environmental impacts and associated negative impacts to human health are still relevant and cannot be addressed by this new application for the same project. This project and application, as you've heard already, have been rejected multiple times by various local entities and courts. The focus of what I want to say today is on air and water and wildlife and habitat resources. Briefly, the applicant recognizes that particulate matter will be introduced into the immediate and surrounding airshed from the mining operation. As far as water, specifically groundwater, a settling basin is identified, but what's it for? Groundwater pumped from the quarry area, blasted and excavated, or for stormwater runoff, or both? Is there modeling that can confirm how much water enters the quarry to be pumped out and held in the settling basin? Is there modeling that shows the settling basin can hold the amount of wastewater that may need to be held back for settling with added precipitation? What are the constituents that would need to be settled out? Total suspended solids, other contaminants? Fractured bedrock was a common issue identified in the previous supporting documentation. Evidence suggests that the bedrock that would be quarried and blasted may already be fractured or become fractured due to the operation of the quarry, resulting in exposure to groundwater that's used by adjacent property owners. Blasting may expose new fractures, leading to issues with groundwater quantity and quality. Contamination of residential wells is one example, and this was outlined in the original supporting documents. Reducing the size of the quarry, hours of operation, depth, and distance to residences does not automatically mitigate this issue, as no evidence has been submitted with the new application that this would not be an issue. Cedar Corps memo dated December 15th, 2008 states that there is evidence that the trap rock can absorb water even without fractures visible or present. In some instances, this was at 22 feet below grade. What about the 8 to 12 feet below grade that's in the new application? A review of the application materials does not provide any analysis for this scenario, which is the newly proposed quarry design for now. Also, the application states that the only pollution sources are from trucks or equipment with leaks. The same potential anywhere as a truck or piece of farm equipment, end quote. That's found in tab 1A of the application. However, pollution to groundwater doesn't necessarily need to be categorized as man-made or artificial chemicals from leaking trucks or tractors, which can be especially cumulative, but also from biological sources such as pathogens or elemental like arsenic or nitrates. The concentration of these pollutants can be increased due to the exposure of and mixing with surface water. As far as that was groundwater, as far as surface water goes, wetlands. The National Wetland Inventory, which is an easily accessible desktop application that any of you can look up, identifies an intermittent riverine stream bed that is seasonally flooded wetland flowing from the direction of the newly proposed footprint into Lotus Lake. How will this impact water quality of the existing wetland that I just identified and Lotus Lake, as well as downstream lakes such as Horse, Rice, Cedar, and Horse Creek? Well, this is a National Wetland Inventory indicated wetland, right? It's a desktop application. The delineation completed previously showed 9 wetlands. Typically, these delineations are only valid for 5 years. Has there been a jurisdictional determination of these wetlands from the U.S. Army Corps of Engineers? The United States Army Corps and U.S. EPA have issued a proposed rule to define waters of the United States based on recent litigation, 2021. Under the new interpretation, the scope of what waters are waters of the U.S. has been expanded and may include ephemeral and or riverine wetlands that may exist on the subject property if there is significant nexus to navigable waters, which it appears to be. There are also newly published stream mitigation requirements as well. If requirements can't be met, then impacts to those waterways cannot occur. Stormwater and runoff. How has new climate data been used to update any of the modeling, if it even exists? For example, the stormwater modeling that uses Atlas 14 has been revised based on recent storm events and updated climatic data. Many of these updates have been completed since the 2009 application and the development of those supporting documents. Lastly, land and wildlife, loss of habitats. Very nice site photos from the previous presentation during the June 15th meeting. Those photos show that the site supports native species and critical habitat for a variety of wildlife species. Specific vascular and non-vascular plants shown in the photos include lichens, little blue stem, white oaks, princess pine, and red cedar. Yes, I said red cedar. It's not invasive, just managed for differently in some grassland, prairie, savanna habitat types. Some areas show little to no ground cover, which is the natural state of sites like this, described as glades, which provide critical habitat for a variety of different species. The coefficient of conservatism, which is a numerical value of different plant species, for some of these is ranked quite high, and those are the species that we saw in those site photos. Lastly, a number of federally listed threatened and endangered species may be found on these sites. I've listed 3 here: the power sheep skipperling, but 2 I want to call your attention to. The rusty patch bumblebee was listed in 2017. The project area for the quarry is directly adjacent or slightly overlaps identified habitat for the rusty patch bumblebee. So the project area meets habitat requirements. Secondly, the northern long-eared bat which was listed as threatened in 2016, is now proposed to be listed as endangered in 2022. There may be winter hibernacula and exposed rock crevices on the site. The Endangered Species Act Rule 4D states that incidental take is prohibited if the tree removal is within a quarter-mile radius of a known hibernacula or a specific set of impacts occurs to known maternity trees throughout the pup season. In summary, the applicant's counsel stated that the decision of the committee should be based on substantive information and not on political will. While political will within the town of Osceola opposes this application and subsequent development of a quarry within the town and the cooperative boundary agreement area between the town and village of Dresser, the argument against this conditional use permit is very substantive and fact-based. Sat here at the previous hearing and listened to hours of testimony. You're sitting here today listening to similar testimony. While the application is new due to the date on the application and changes to quarry dimension, depth, quantity of material to be quarried, traffic, processing, and economic impact, which, by the way, generates less than the original app and less than surrounding residential development. The impacts to the health, natural resources, way of life, property rights of adjacent landowners, and the economy still exist. They still exist, and they would be negatively impacted and amplified. County staff prepared the tabular handout, I believe Jason did, that summarized the topics for the previous application and the current application side by side. I got different numbers than you, but they're very similar. You'll see why. Of the 23 topics listed in that handout, 12 are categorized as the same, right? The same between the original app and this new app, or have the same description. 5 topics are categorized as either not provided, not clear, or unknown. And the economic impact topic only lists and addresses the potential tax revenue from the quarry, not the revenue from protecting existing adjacent property values and future residential development tax estimates. Not to mention the proposed smaller quarry in the 2022 application, the one in front of you that's supposed to be 10 acres, is stated to provide the same or more jobs than in the previous application. So 5 topics of the 23 are listed as different from the previous application. And of those 5, you said 4, of those 5, 1 is the name of the applicant. Not very substantive. The remaining topics are short-term changes since the applicants acknowledge that the size of this quarry will be increased. Size and the scope of the operation at some point once they have approvals that begin with this conditional use permit. These considerations form the basis for rejecting the previous application and are the substantive bedrock, no pun intended, for denying this application, hopefully for the final time. Thank you very much for your time. Have a good day.
Thank you. We have hers to read. Is Jason there?
This comment is submitted by Amy Middleton. She's a county board supervisor. She's not able to be here today. So it's dated June 29th, 2022. My name is Amy Middleton and I live in the town of Osceola. I am also the county board supervisor for District 10 area in which this mine is proposed. I want to speak to you based on my personal experience living near a hard rock mine, as well as someone who was on the town of Osceola Plan Commission during the first application for this mine. I will share the concerns I am hearing from our community as well as talk about the driving tour Supervisor Rowdy and I did. My experience. I live over 3/4 of a mile from the Dresser Trap Rock mine. The mine has been in operation for decades during the time of blasting neighborhood homes rumble and vibrate. It feels like a train going by. A friend from California was at my house and thought we were having a class 4 earthquake. On certain winds, it's easy to hear the rock crusher grinding away and the rock being dumped into the containers. The trains haven't been running lately, but when they dump into the train cars, it's quite loud. As I said, I live over 3/4 of a mile away and still hear and feel the impact of hard rock quarrying. It is because of this neighborhood impact and wanting to be a good neighbor that Dresser Trap Rock has focused for many years on creating a buffer of land around their facility. This has reduced the impacts to homes in this area. They roughly own between 2,000 and 3,000 acres of land around the mine. And she had submitted the map. DTR, yep. Okay, so here is a flat map and the land in red is what Dresser Trap Rock quarry owns. So that's the area. The red line shows how the extensive land buffer is around Dresser Trap Rock that protects the neighborhoods from mining impacts. For 12 years, I served on the Town of Osceola Plan Commission and was in the thick of reviewing the last application. We studied that application very extensively. We hired experts to look at the issues. The issues are the same in the current application before you today. On May 31st, 2022, Doug Rowdy and I took a drive to look at some parks and trails projects and to get orientated to the mining going on in my district. We both serve on different trail committees, and I wanted to show him the projects my committee was doing. We started at the Polk County Information Center and talked about a new trail reroute and services going in at the Gandy Trailhead. We then proceeded to the area near Dresser Trap Rock and drove to the neighborhood a mile away where the mine noise and vibrations are felt. Next, we drove to Dresser Trap Rock offices, and along the way, I was able to point out that the mine owns all the property we drove past leading up to the mine. We were then taken around Dresser Trap Rock to see the industrial nature of mining activity. That would be the operation photo. Okay. This slide shows a small portion of the industrial activity that goes on with mining. This does not capture such sounds as the crusher busting up the rock or truck or traffic dust. Nor does it capture the massive footprint of this operation needed for storage of piles, loading of material, and the length of the railroad track needed to load cars and back them into place. It also doesn't capture the depth of the mine pit that helps mitigate noise. We then proceeded to visit a neighborhood home adjacent to the proposed application site to get a feel for how close and tight everything is to each other. We met with Dan Birch and Bob Wright, both of which you have heard testimony from. We then drove through the adjacent Lotus Lake Estates development to understand how close houses are located to the proposed mine site. Lastly, we finished with driving through Polk County's Lotus Lake Park and saw the improvements made by the park and that by our Parks and Recreation Department. We also drove past the terminus of the Stour Seven Lakes Trail to point out its location. Let me say a couple words about the applicant's proposal of connecting the Stour and Gandy trails. The land owned by the applicant is a very small portion of the land needed to connect these two trails. There are several significant landowners between the Stour and Gandy, and many are unwilling to host a trail. This challenge would be in addition to any role the Wisconsin DNR and the railroad would have in securing a trail route. So I don't want us to be swayed by the offer to connect these two trails. There's a lot to that endeavor outside of the applicant's control. This is the completion of our driving tour summary. here's what I'm hearing as community concerns. This is a very important, impactful issue in this district. I get many phone calls and emails from concerned citizens. Many express concerns over the loss of property values, truck traffic, dust, noise, and that to mention a few. The area residents bought their homes and moved into the neighborhoods adjacent to the proposed mine before any mine was there. The neighbors surrounding the proposed mine are hardworking taxpayers who invested in their homes, and it's not fair to take that away from them. These are families that expected that their neighborhoods would remain calm, quiet places and not have an industrial mine next door. Future housing growth options and values in the area will be compromised and will result in a loss of tax revenue for the town and county. Another concerning issue is when I saw the applicant's presentation and the slide talking about how we all need and use trap rock. The fact that the trap rock is an important product for our use is not in question. But I questioned the slide that the applicant used of a house, roof, and a driveway. These two images were from the homes of community leaders opposing the mine. One image was taken after traveling down a private road. These photos that are targeted people's homes were concerning. This is a small community and it seemed invasive and aggressive to key community leaders. This is not a way to be in any community and specifically in a small community, and certainly not a way to treat one's neighbors. Another community concern I'm hearing about is the option of sending this back to the town of Osceola. The past several years has not been easy at the town with near constant staff turnover, vacant supervisor seats, and investigation. Additionally, the plan commission was dissolved and restarted to remove old members. With the new plan commission, a member was recently removed from the committee when they asked about getting educated about the proposed mine. Finally, this proposal was already denied years ago, and I see no evidence that anything substantial has changed. The impacts to the community and incompatibility remain the same. I urge you to deny this application. Thank you for your time. That was Amy's comments. That would be exhibit 73.
70 what?
73.
What was 71 and 2 then?
That was 71 was Sonia Degerstrom's testimony.
Okay.
And 72 I had is those documents that she had submitted with it. So that was the email or the letter to Steve Stroshane and then the town minutes from 2016 regarding the hospice, just supporting, and then Amy's would be 73.
Thank you.
And up is Melissa Ward.
Hi, I am Melissa Ward. Our family lives at 2127 105th Avenue within earshot of the proposed mine. We are not in favor as for the reasons that have been stated, not today, not tomorrow, not ever.
Thank you. A Valerie Fall.
No Valerie, then a May Bretbach.
Morning. I'm May Breitbach. I live at 2107 105th Avenue in Dresser, Wisconsin. In 2009, I spoke at more length and in detail in opposition to a blasting quarry based on the negative impact and incompatible land use to the surrounding community. The same valid concerns exist today, as you've heard, despite changes that the applicant alleges they have made. Over 20 years ago, I began my search to purchase rural land, build my forever home. I was looking for a place similar to that which I had been raised, surrounded by nature, with foraging and hunting resources, as I'm on limited income, that was safe and provided an environment supportive to mental and physical well-being to balance a stressful workday. I found a parcel of land in Dresser, Wisconsin, that made me feel like I was at home. And on that land, I built a home that I custom designed specifically for my needs at that time, as I had physical limitations then, as well as my anticipated needs into and beyond retirement. It is quiet and peaceful, where I can enjoy the sounds of birds singing and leaves in the wind. Prior to purchasing my property, I had the opportunity to assess the potential risks and impact of surrounding property and businesses on the environment that I was in search of. The trap rock blasting quarry in Dresser already existed at the time. I was contemplating purchasing my property, as were a couple of non-blasting gravel quarries nearby, a rod and gun club, and the Trollhagen ski area. As the gravel quarries are non-blasting and do not operate crush at the capacity of the proposed mine and do not generate much traffic by my property, they have little impact. Noise from the Rod and Gun Club and Trollhagen, including special events such as the mud runs, are transient, very short-lived, and thus tolerable. The point being, I was aware of these and had opportunity to take them into consideration prior to investing in the land and the community in which I live. I invested a lot of time, effort, and money into the collaborative building of my home, contracting through local businesses, as well as performing a lot of the work myself with friends and family. I've built memories at this location. I love this community and this precious river valley that I've invested this time and money into. I've cultivated crops, trees, managed the resources that are on the property so that I could be self-sufficient and live independently. I've invested into the community and have built relationships with neighbors. I rely on the resources of the property. I forage and hunt for food. It provides me with safe and reliable water, shelter, and nature for my wellness. I'm able to utilize these resources without negative impact to my neighbors. Out of respect and consideration, I take into consideration what my actions might impact, or what impact they might have on neighbors, and I'll even contact them in advance if I feel like what I'm planning to do on a weekend or any activity that I'm performing might somehow be disruptive to them. For example, I avoid cutting wood when they're out hunting with their children, bringing up the next generation of outdoorsmen. In regards to the Blue Rock Quarry application, I have the same personal and community concerns that I had with the previously proposed mine, such as water and well, environmental impact, noise, property values, traffic, safety, and wellness. In regards to water, I live north of and at a higher elevation than the proposed quarry, and my well is approximately 100 feet below the surface within the basalt, the trap rock. What happens if blasting or basalt removal at the location of the proposed quarry changes the water drainage or holding patterns, resulting in a compromise of my only water source? Who covers the cost of providing me with a new well? How will that causation be determined or funded? The applicant has suggested they may be using 500 gallons of water per minute. To provide a visual reference, a large hot tub holds 500 gallons of water. 500 gallons per minute. How does one go about obtaining that volume per minute over any duration of time without impact to their own or surrounding water sources? How many current wells could be at risk if there's an adverse effect of the blasting quarry in this location? The The applicant has suggested that there has been no groundwater contamination caused by a quarry. Do not misinterpret this to mean that there has not been any surface water contamination. Groundwater is not the same thing as surface water. Groundwater is water in the aquifer below the surface. Surface water is just that, fresh water on the surface that is sent into rivers, lakes, ponds, streams, etc. I spoke of numerous instances of quarry contamination of streams, etc. in the 2009 hearing. My searches found that many of the licensed quarry professionals operate under a ask for forgiveness mentality, leaving the community to deal with the cost of the adverse effects. What do we know about the company that will be doing the actual mining? What is their track record? How do they operate? Do they operate under several different companies to avoid having a track record? How many locations are you able to see the lotus flower generally growing naturally? Are you aware that the sacred lotus contains chemicals that have many health benefits, one of which is killing cancer cells and bacteria? Are you willing to take the risk of potential adverse impact to drinking water supply and surface water integrity? My property, my home is my sanctuary, my peaceful Engedi that supports my health and well-being. I have concerns related to noise, road traffic, and rail traffic that pose a risk to this. The applicant claims there could be only 3 to 5 blasts per year, with crushing being the source of the most noise at a quarry. And they would manage sound levels to be less than or equal to 55 decibels. I'm curious how they will manage that in consideration of the following noise levels: 40 decibels at quiet office, 60 decibels normal conversation, 60 decibels normal conversation compared to 55 decibels for a blasting quarry. When 85 decibels is loud traffic, Troll Hog Memorial Day mud run event is easily heard at my house all day. 135 decibels is a jackhammer, 140 and 160 for a rifle blast and a shotgun blast respectively. What is the noise level of crushing, loading, backup alarms, which I've since heard that they may try to mitigate or not have those, etc., which will not be transient noise. Regardless, assuming they can manage the blasting and crushing noise to less than or equal to 55 decibels, 11 hours from 7 a.m. to 6 p.m. of a normal conversation noise constantly is a negative impact to well-being at any presently peaceful home property. The applicant estimates hauling traffic of 100 trips per day, which equals about 10 trips per hour based on a 10-hour day. A typical walk in a residential area is about 1 hour. So welcome to 10 more vehicles passing you in your very relaxing walk. When were the Wisconsin DOT traffic counts performed that were used to calculate the 5% traffic increase? An increase in hauling and employee traffic, not just the hauling traffic, could have an adverse effect on the safety and the wellness benefit of a peaceful walk in our community. What details do we know about the proposed rail traffic? How many, how often? What duration of delay would this have to emergency vehicles? How will it impact fire hall response time and routes, considering the track is right in between the fire hall and my home? Is there any benefit that would outweigh the risks associated with this proposed quarry operation? Look closely at what jobs and revenue would really benefit the existing community. Many of the jobs seem they would be requiring, but they're specialized jobs that may not have local talent or skills to fill them. Would the proposed tax revenue be realized, or would it actually go outside of our community? As a resident of the town of Osceola, I see no benefit that outweighs the many risks of negative impact to the community and the well-being and safety of its individual members and their interests. As such, I respectfully ask that you deny the conditional use permit application for the Blue Rock Quarry. Thank you.
Thank you.
The last one is Melissa Germain.
Hi, I'm Melissa Germain. I live at 822 214th Street in Osceola, in the Lotus Lake Estates Development. Dear committee members, first, thank you for allowing me to come back to speak to you. I was in attendance for the full duration of the meeting on June 1st, 2022. What I speak about today will be based on my original plan for verbal comments and includes the notes that I made over the course of the meeting on June 1st. I will be speaking on behalf of myself, my husband, and our family. We heard on June 1st that the Blue Rock Quarry had considered and addressed community concerns by paring back its original plan. However, I am a community member and I am still concerned. I live in Lotus Lake Estates Development with my family. In 2007, we moved there from the city of St. Paul in order to have a more peaceful, less hectic life. We selected our property based on the location, the scenery, and the quiet. Then 2 years later, we learned that a new trap rock quarry might begin operating near our property. Our immediate concerns involved potential noise, our well and water quality, ground vibrations, and dust in the air. I attended numerous meetings at the town and county levels, and we were thrilled when several agencies denied the request. The Land Information Committee deemed that the quarry would have a negative impact on the area. We were relieved that we would not have to worry about this again. Now the request has returned, and our concerns have returned. While it is true that landowners have a right to do what they want with their property, it is also their responsibility to be good neighbors. While I can see that Blue Rock Quarry has made some changes in its original proposal, I don't believe its proposed mitigations contain enough proof to show that it would have a positive impact on the area. First, the supporting documentation is at least 14 years old. All documentation presented was accurate within 5 years of the original application. The traffic study was completed 16 years ago. The air, land, and water situations could be vastly different now. How do we know they have remained the same and will be impacted the same way without accurate supporting documentation? Secondly, I'm concerned about the quarry's assurance that it will monitor the air quality using current state-of-the-art methodologies. This is incredibly vague for proposed mitigation. What is an example of a current state-of-the-art methodology? How do we know that the amount of dust in the air will be in fact controlled? Thirdly, the Blue Rock Quarry's revised proposal mentioned that the noise level maximums would be similar to those required in the city of San Diego. It wasn't clear, however, how and where the noise levels would be measured. How do we know that the noise from pouring a hard rock won't cause a daily disturbance to the neighbors? Additionally, I'm concerned that the location of the quarry at the top of a hill would amplify the sound across the valley. We simply do not have enough information in these proposed changes to ease our worries. My fourth question is about the results of the second survey that was sent out. I do not know when this was sent and to whom. My husband and I never saw a survey. I don't know many others who live in the area who received the second survey from Blue Rock Quarry either. This makes me wonder, how accurate is that data? Finally, the attorney for Blue Rock Quarry referred to Wisconsin's Act 67 of 2017, which provides the requirement of a political subdivision to grant conditional use permits under certain circumstances. What I'd like for you to consider is that in this act, the county's decision to approve or deny the permit must be supported by substantial evidence. That's in section 2. From what we saw in Blue Rock Quarry's presentation, there is no substantial evidence to prove that the operation of this quarry would not have a negative impact on our area. Therefore, the county has substantial evidence to deny the permit. Please deny this permit so that the Blue Rock Quarry does not create a negative impact on our quality of life and on our health. Again, thank you for the opportunity to speak to you today.
Thank you. All right, that'll end our public comment part. What we'll do for, you'll have rebuttal, but let's take about a 10-minute break. Stretch a little bit, we'll come back 10 or 15 minutes, and then we'll start with the rebuttal. It just keeps going, don't it? Yes. Oh, I thought Jason was gonna. You're gonna tell us that exhibit set.
Yeah. So
Let's
just for the
get that so
record,
we know what's in there. That
okay,
it's in the record in case they add any.
for the record, today what we've added, we've got exhibit 69, which was the PowerPoint presented and that by Attorney Vivian. Exhibit 70 was a copy of the letter from Aaron Degerstrom that I read into the record. Exhibit 71 was Sonia Degerstrom's testimony that I read into the record. Exhibit 72 was the documentation submitted by Sonia. That's that letter and that from the Weld Riley firm and that to Steve Stroshane and the town minutes. And that for those 2 meetings regarding Haas, sand and gravel. Those 3 documents, I put all as 72. Exhibit 73 was the testimony I read into the record from Amy Middleton. And exhibit 74 is something that I haven't had in the record before, but it was the PowerPoint presentation that I did on June 1st. So that one was the one created by me. So I didn't have a copy of the slides at that time, but I do have a copy in the file now.
You do that one. Okay.
So that's exhibit 74 is where we're leaving off. Or we're leaving off. So.
All right. So we are ready for rebuttal to answer some of these questions that we have. You have a presentation to have to answer some of these to start with?
Yes, Mr.
Okay.
Chairman. While the presentation is coming up again, I just wanted to thank you, Mr. Chairman, and the rest of the committee for extending this to a second day. And we appreciate your continued consideration and review of this matter. And as always, my name is Anders Helquist. I'm with the Weld Riley firm in Eau Claire, Wisconsin. And I represent the applicants in this matter. In terms of some overarching items that, let's just keep this in mind as we're going through the rebuttal and as you're going through your discussions, I'd ask you to just keep these things in mind. First, we're dealing with an applicant here, 3 landowners that have long ties to the community. They were either born here and have lived here their entire lives, or they're living on their grandfather's farm. They've been here for generations or decades. These are folks that are looking to better the community by creating and using a resource that, God has placed right here in Polk County and isn't going anywhere. So, unfortunately, they can't move the rock unless they mine the rock. And mining that rock can provide revenue and jobs for Polk County and the neighborhood. Dresser Trap Rock is a long-term mine and just shows the sustainability and long-term benefits of an operation like this. Second, this permit, as you know, is the first permit in a very multi-layered, heavily regulated process. The committee issuing the permit here does not mean mining or blasting or processing occurs tomorrow. They still have to go to the town of Osceola and get their license. They have to get a reclamation permit from the county. They have to get DNR permits for stormwater, air, and if there are any other environmental impacts that are unknown, or speculative at this point, those have to get addressed before they can put a shovel in the ground. So what the applicant is simply asking for is this conditional use permit to be granted so they can move on to the next permitting steps that provide additional layers of protection on top of your conditional use permit with any conditions that you impose. There's a lot of reference to the prior mine, and I think trying to minimize or really trying to ignore how this application minimizes the impacts that were perceived in the prior application. This proposed mine goes from 60 acres of mining to 10 acres. It self-imposes hours of operation, months that they can operate, days of the week that they can operate. It self-imposes a strict noise limit that's frankly more strict than like the state of Minnesota requires. There are greater setbacks than existed with the Kramer mine. 1,300 feet from the nearest residence. Overall, there are reduced impacts with this reduced mine size. And that's something to, again, keep in mind as you're going through this process. Act 67 came up, a few times, and I was very candid with the committee back on June 1st. There are a couple parts of Act 67, but the first part is if the applicant meets or agrees to meet the county standards, the county shall issue the permit. Now we have to provide substantial evidence, but to deny the permit, you also have to have substantial evidence to deny the permit. And as you're going through the different conditions that you'll be evaluating, those 12 to 13 conditions that you're required to look at, to the extent there's ambiguity in those, state law now requires that ambiguity be interpreted in favor of the free use of property. And that's how a court would interpret those now, not back in 2009. As it relates to Mr. Vivian's presentation, a couple things. Unfortunately, it deals with some of the frustration that the applicants continue to see and feel through this process, where there's a misrepresentation of what has actually changed from the old proposal to the current one. Their attorney said only 4 things have changed between the old permit application and this one. And that's not true. The 4 things that he said were the depth, no rec plan, the quantity is market driven, and there's fewer traffic trips. Those were the 4 things he listed. I mean, the biggest thing that he decided to exclude, and I don't know, maybe he thinks the committee wasn't paying attention to it, is that this mine site has gone from 60 acres to 10 acres. That is such a huge change, substantial change, that trying to rely on an old court case or an old committee decision is, frankly, it's not precedent and it's not proper. Additionally, as I mentioned, we have the self-imposed limits. That's new in terms of operations and hours and months, and days of the week. The number of trucks, round trip, truck traffic trips have gone from 400 to 100. He can talk about potential changes to the corridor, but when you reduce your trips that significantly, you can't rely on some speculative growth to say that those reduced trips somehow create some horrible impact today. there are different depths here, and that's important. Where they're not going down as deep, and they did that in response to the force group, or whatever they were called back in 2009, saying they were concerned about mining below the level of Lotus Lake. So you know what these folks did with their application? They said, we're not going to mine below Lotus Lake. But you know what you're hearing, and again, what's frustrating for these folks is that this is like the game of whack-a-mole. Maybe that dates me if you went to the old arcade. So maybe that I'm an 80s kid, all right? So I remember the whack-a-mole. And you know, you hit one mole, and another one pops up. And that's what they're doing. They meet one community concern, and then they shift it around to say, oh, well, mining above Lotus Lake is now a concern. They've significantly addressed some of the major concerns from the prior application. In terms of size, in terms of the depth, in terms of the setbacks, which have been increased significantly, and reduced truck traffic from 400 to 100 trips per day. And yeah, you heard about the rail last time. The rail wants to know there's going to be a mine there before it invests capital to improve the line. You can't get the improved capital from the railroad unless you know you can use that to haul out material. I mean, that's such a common sense economic discussion that, you know, it shouldn't need to be said, but apparently that's now being used as a strike, saying, well, you haven't developed the railroad yet, so your representation about using the railroad isn't proper, right? That's just not a proper basis to deny this application. Let's see here, can I, you know, additionally, in terms of Mr. Vivian's comments, you know, he cited to a whole host of plans that weren't, or reports that weren't provided. But your ordinance does not require those reports and plans to be provided as part of the application. It doesn't. And he's right, that you can ask for those as conditions. Stormwater permits, we're going to have to provide a stormwater pollution prevention plan when we're permitting it with the DNR, and an erosion control plan when we're permitting stormwater with the DNR. And those should be in getting all required permits from the DNR or the Army Corps of Engineers or any other governmental entity should absolutely be a condition of this permit. And it's one that the applicant would embrace because they need to follow the law and they will follow the law. Ironically, you know, they point to the dated nature of the Kramer reports, which would have supported a permit issuance if the committee had decided to go that way back in 2009. The committee decided to accept the opposition's reports. But they, you know, the opposition says, well, don't rely on those old Kramer reports for a 60-acre mine, but rely on our noise and vibration experts and their old reports from 2009 for a 60-acre mine. I mean, it's a bit ironic and it's a bit hypocritical. And relying on old reports in an old committee decision using old law is not substantial evidence to deny the permit today. This committee has heard a lot of testimony. They've heard a lot of the presentations. And you know, our request on this is really simple, and it's to request issuance of the permit. And we think the findings of fact that you can make would support issuing the permit under each of the conditions. And we've given those to you. What I'm not going to do, though, is try to pretend that I'm a member of the committee and pre-write your findings of fact for you. You know, you're an independent committee, and you'll be able to make those findings of fact on your own. And we request that you make those in favor of granting the permit. We didn't provide a 10-point list saying exactly how you should how you should rule, especially when those findings of fact are based on outdated reports for a 60-acre mine. It's based on a court case that didn't have to follow Act 67. And it's based on, again, a 60-acre mine. So just a couple points. Now, we do also want to emphasize that the Blue Rock Quarry here is compatible with the surrounding land uses. That's something that we've heard as an issue. And we'll show this later in the slide presentation, but there are fewer residences within 1 mile of the Blue Rock Quarry than any of the other quarries or tract quarries in the area. And we'll just keep that in mind. We already went through the changes from the previous application. The Blue Rock Quarry is zoned correctly, and we have that reservation of metallic minerals under the DNR, which encourages this type of land use and to preserve its ongoing use. Blue Rock Quarry, I already outlined Act 67, and we believe we meet the requirements of Act 67, and we believe the county should issue the permit. Next. We talked about the active quarry being 10 acres over 10 years. This is not a 60-acre quarry. And if there is going to be expansion in the future, that means coming back to the committee. And, you know, maybe at that point, if they go up to 60 acres in some future time, which they're not proposing to do, you know, maybe that's when you look at prior, 12, 13-year-old studies from the opposition group. Not today. So in terms of sound and noise, you know, there's one thing here that I already went through how they're self-imposing the 55 decibel limit, which is stricter than any other standards here. And they're choosing to follow that standard because they believe they can meet that standard at nearby residences. And that should be a condition in this permit. You know, we heard from how many folks in public comment, Jason? Sorry to put you on the spot.
Well, we had originally 20. Valerie Fall was not here. Jim Dunham, and then was here on the first, but not today. There's another one, Carl, Frank, so that's 3. So we had 17 total. And you know, verbal in the hearing, and that there was numerous written ones.
Yeah.
Too, so.
You know, in terms of what I heard at the hearing, you know, with the 17 public comments and the folks that are passionate and come to speak at this, which I appreciate. I mean, it's I understand why they're coming here to speak. You know, what I really didn't hear though was any parade of folks coming in and talking about the impact of the existing mines here. A lot of it was speculation about a 10-acre mine while ignoring Dresser Trap Rock and the other quarries. Now, today, you know, we heard Amy Middleton as one that stands out, as she's someone that came and opposed the, well, she didn't come here. She had someone else read her comment, but she, you know, made some allegations about living 3/4 of a mile away. She's the only one that was providing, that I recall, specific opposition based on a specific experience out of 17. If there were a lot of bad impacts from Dresser and Haas and Right Way, I would have expected a lot more people to have shown up to testify about how those actual operating mines have an actual adverse impact day to day. Instead, we get Amy Middleton, Supervisor Middleton, who is someone who decided to take a committee member out on a private tour, look at the site before this hearing, who picked up 2 opposition members to visit the site. And we didn't hear anything from, I mean, we need to note that Ms. Middleton was supposed to say everything that was said during this private tour, and she did not provide that. And we didn't hear what the opposition provided in their private tour of the neighborhood. And I think that creates an issue that I at least need to raise for the hearing. But you have someone that's extremely biased that's, calling it an earthquake, which, let's look on the flip side of Ms. Middleton's comments about this being an earthquake. Now let's look at Ryan McGinnis, who testified back on June 1. Ryan had a lot to say, but 2 times he mentioned his experience living next to, or being next to Dresser Trap Rock. He lives about 2 blocks south, about 900 feet away, much closer than 3/4 of a mile. And he said, what he hears is the faintest of echoes. That's the noise impact that he actually experiences at a large scale mine. In terms of vibration, you're asked to rely on some old reports from the force for the town expert. Again, this is in relation to a 60-acre site. But their own expert back in 2009 said he wasn't looking to see whether the quarry meets the standards or not. In his words, as I said, I guarantee you they do. That is a given that they'll meet those standards. And again, some of these speculative or more larger crowd-driven sentiments back in 2009, you were able to, a committee was able to use to justify a denial. They can't justify that denial today under Act 67. We already talked about how this 60-acre vibration study with closer to residences and much larger in scale to be a negative just doesn't equate now. Whereas the Kramer one, relying on that larger site, it could have been supported if the committee wanted to go that way. Setbacks are 50% further from the nearest residence than they were in 2009. You've got a couple other statements that we heard throughout here, that there are no alternatives to backup equipment beepers. White noise backup beepers are kind of an MSHA standard. It's something that's used regularly in the industry, and that is what the applicant has proposed here. And that's something that that you have in terms of the handout that you've been provided. There was a question about an Osceola town survey. And this comprehensive plan survey said 53% agree or strongly agree with gravel pits being appropriate. This would be one of the examples of the whack-a-mole.
When you read that though, it says, survey says quarries are okay, and then you say gravel pits. Is it one or the other?
A gravel pit is a quarry.
They're 2 separate things. That's why that's kind of misleading a little bit right there.
Okay, well, the intent isn't to mislead, but in our minds, a gravel pit and a quarry are both non-metallic mining operations. But that being
That's
said,
misleading, I think, because a gravel pit doesn't blast
okay,
and a quarry does.
oh,
So there's
crushing at both.
crushing at both, but there's not blasting at both.
Okay, I understand your point,
All right.
thank you.
Okay, thank you. I just caught that. Go ahead.
In follow-up to the chairman's question, if you Google hard rock quarries, they list the rock that are in hard rock quarries, and it's not gravel.
Okay. Noted, and thank you.
Yeah, just, okay.
I think it might have just been a little disagreement on the terms, but either way, whether a survey says they support it or not, the point is it's non-metallic mining is not widely disfavored in the town. I think we can agree that gravel pits and quarries are both non-metallic mining. And, frankly, even if the survey showed 95% were opposed, that's not substantial evidence to deny an application here. Again, we don't want engine braking because of the noise concern. So to address the noise concern, no engine braking. Well, now they're bringing up a safety concern, but that just there's no support for that position in the record from the opposition that trucking would be unsafe. The quarry depth again was raised due to Blue Rock's hidden concern for Lotus Lake was one statement. No, it was raised because of the previous concerns raised by the force group. I think maybe this is where we're getting into the questions about a difference between a quarry and or a trap rock quarry and a gravel quarry. There's that statement that Blue Rock isn't the same as Haas or right way. Again, what they've proposed is 3 to 6 blasting shots per year, which are very short in duration. And most of the day-to-day noise that would be generated from this site is identical to these other quarries where it's crushing and truck traffic. There was one of the applicants was recently at, was it Abrahamson's?
No, you can't shut the doors. It's an open meeting. No. Yeah, at least one.
So talking about these 3 to 6 blasting shots per year and the statement that this is an earthquake. Well, one of the applicants was at the Abrahamson nursery a couple weeks ago. A few weeks, probably more than a couple weeks. Yeah, she was picking up flowers and she heard kind of a whooshing noise. Is that the right way to? Just a rumble. Looked around, asked the worker at the nursery, and what was that? And she's like, oh, I don't know. It was very quick and it passed. And no one was grabbing onto the tables because it was an earthquake. Everyone was continuing to shop for their plants, and there was no disturbance to that nice, quiet nursery business. In fact, the applicant called up a dresser and said, "Did you guys happen to blast about 30 minutes ago?" And the response was, "Yep." And the question then was, "That was it?" And the dresser trap rock guy said, "Yeah, that was it." And so it's not the 3 to 6 shots per year are not, as the opposition says, a constant earthquake, which we'll get to that later. And again, in terms of compatibility, we discussed how in 1 mile it reaches fewer residences than any of the existing quarries. And Dresser Trap Rock is actually closer to privately, not Trap Rock owned homes than Blue Rock will be. So in terms of the Blue Rock Quarry, measuring a mile out from their proposed operational boundaries, they have 140 residences within 1 mile. 140 within 1 mile. You've got the Haas Quarry, 152 residences within 1 mile. 152 within 1 mile. For an 18-acre quarry in processing, which is larger than, well, it's comparable to the proposed operations here. The Right Quarry, 337 residences within 1 mile on a 40-acre quarry and processing site. 337. And then in one of the other presentations, it talked about Dresser Trap Rock, and there was the comment that this mine isn't like Dresser Trap Rock. And to some extent, I agree. It's a lot smaller and it has fewer impacts than Dresser Trap Rock. It's smaller in its scale. It's not as close to homes, and there aren't as many homes with the proposed Blue Rock Quarry compared to Dresser. There are approximately 240 unowned Dresser Trap Rock properties within a mile. And they have their 225-acre quarry and processing site. And you can see where this branches out. This isn't playing some type of game where they're going, where we had to go out to the outer boundaries of what Dresser Trap Rock owned. If you remember, that's what one of the opposition did with ours. They went to the far north site and went to the outer proper boundary and tried to extend it out. We're not going off of this. We're going off of their boundaries on the north and south. Blue Rock has fewer residences within 1 mile than any of the 3 other permitted quarries here. It's compatible. Not to mention the distance to the privately owned residence from Dresser Trap Rock on the blast areas is less than 1,000 feet. This isn't a property owned by Dresser, a home owned by Dresser Trap Rock. This is a home owned by a private resident. Blue Rock Quarry, their closest home is 1,300 feet away. There's another private home, not owned by Dresser Trap Rock, that's less than 900 feet. Again, which is closer than any Blue Rock Quarry setback. So, I talked about this, the frustration with misrepresentations. And this is just, again, the type of thing that the applicant is dealing with and that you as the committee have had to deal with in terms of exaggerating impacts from this proposed site. You have folks trying to get signatures on a petition to oppose this. And they go around, they talk to neighbors and they say that 200 trucks a day would be going past. That's false. And they said that there would be shaking like an earthquake from constant explosions. 3 to 6 shots that kind of feel like a low rumble and are over in 2 seconds is not constant. It's not an earthquake. And so that's, unfortunately, some of the tactics that we've seen before the hearing. And I understand concerns folks have, but that doesn't give them a license to state what they've stated here. In terms of the petition that they've circulated, even with their tactics, again, this is not substantial evidence to deny the permit, but it's less than 5% of the town's citizens. Lotus Lakes, 90% of the residences did not sign the petition. Trollview Estates, 73% of the residences did not sign either petition. And of course, in Polk County, less than 1% of the citizens of Polk County signed any petition opposing this. Again, we believe the Blue Rock quarry is compatible. It has fewer residences within 1 mile than any of the other 3 quarries. This is a long-standing quarry that started in 1918, and there are other long-standing quarries in this area. And we believe that we provide substantial evidence based on the application and the proposed mitigation, that when you go through the 12 or 13 criteria in terms of safe and healthful conditions, the noise consideration, traffic, et cetera, and we went through those the first time around. I'm not going to belabor it again. At 1, you have support to approve this application. 2, you don't have substantial evidence to rely on old reports to deny the application, and those old reports are based on a larger mine than what we proposed. And 3, the applicant again will meet or will agree to meet all of the standards and conditions that you impose. And when that happens, the county shall issue the permit. So we'd respectfully request you issue the permit, and we look forward to your discussion on this. Thank you for all of your time. And if there are any questions, I'm sure the applicant would be happy to answer them. Thank you.
All right. So committee members, whatever questions, let's start from this. Why was there no scale drawings? Let's just start right there. I got a list right here. Because we're showing you're comparing an old permit for a new permit, which this is supposed to be new by itself. Don't you think, or not? I mean, it doesn't, we're comparing something that's 10 years old. We have none of the studies. And you just say no mitigation or nothing. I mean, what, we have to have some of this information to make any kind of decision, I would think. I mean, even Act 67 says, yes, we can put conditions on. But how do you put a condition when we don't even know what you're doing?
Well, we've identified the areas where we're going to be doing the mining, where the processing will occur. And setbacks have been shown to the committee with the handout that you have.
With the newest handout that you gave today, that one?
Yes.
Because otherwise, like I said, there's just big marks of it. All right.
And if there was a scale map requirement in the application form itself, I didn't see anything that said a scale map. But if that's something that the committee, desires, we'll provide a scale map. But the setbacks are, based on the county's GIS system, which we presume is accurate.
Assuming it's accurate.
I have no reason to believe it isn't. Jason, I assume you have no reason to believe the measuring tool on GIS is inaccurate. So, but it's a good question. Thank you.
All right. Now the wetlands, when they asked about some of that stuff and you're going to put water into them, is that that's a DNR issue, is it not?
That's a DNR issue. Yep.
So how do we know? What if you don't get that permit?
Then this doesn't operate. And we don't meet that. And if you put that condition in saying we have to get all required permits,
Well, of course you'd have to get them all.
Yeah. And then we're,
But
then
why
we're
would we
not,
give you a permit saying, go get some other ones when you need another public hearing for some of these other ones? The reclamation plan has to have a public hearing, correct?
yes, yep.
All right. So I mean, some of these things would have to be done ahead of time. We're giving you a permit, just kind of saying, do whatever you want, kind of, almost, is the feeling. I mean, you see what I'm trying to say? We have no, you don't have evidence of this stuff, except you say you're gonna do it.
So, it's, this, the application and the permit that we're requesting isn't do whatever you want to do. It is, here's our proposed size and scope of the mine. Here are proposed operational limits that address previously raised concerns. And to the extent that there are concerns about stormwater or wetlands, those must be addressed with the state. I mean, that's not something that's trying to be ignored. It's something that has to occur. But quite frankly, if they're going to spend tens of thousands and frankly hundreds of thousands of dollars to get the engineering for these additional permits that come after, it's kind of unfair for them to spend six figures on those other permits if we come back to the committee and then the committee says, no, you don't get your conditional use permit. So that's where, when I'm talking about the layering of the permits, this conditional use permit really is the first one that allows them to at least explore spending their significant money on the more intensive environmental permits. And that's where these conditions that you can put in, which can be quite broad, like obtaining all required permits, is a very appropriate condition. It's a very fair condition, and it provides a lot of additional protection where if they don't get a permit, or if there's, heaven forbid, some issue pops up, this comes back to the county committee and it's subject to revocation. So it is not a license to do whatever they want. Operational restrictions have been proposed. It's to a very limited area. And so that's why we're requesting you come into the committee first.
Still, okay.
It would kind of be like,
Yeah, go ahead.
It says in the application that to return and continue a previous quarry operation for the processing of basalt rock. When's the last time that there was a quarry operating on that property?
that was back in the 1922.
Another question I had, you mentioned that the rail, and this is kind of going back to what you're saying now about these permits and stuff, because it's kind of like, what comes first, the chicken or the egg? You said the railroad wants to know if there will be a mine before they invest in a line. But Mr. Thorman told us last time that he had never talked to the railroad about this. So how do you know the railroad, if you talk to the railroad and they tell you what they need more information, or they need this permit before they would consider this?
I have not talked to the railroad, but I've talked with the railroad in other mining operations and permitting other facilities. And, a rail is not going to agree to like a transload or a rail spur agreement until they can say, okay, here's the plan. And here's like the guarantee that we know you're going to have product move off site. I'm trying to think of like an agricultural analogy here where, you're not going to be buying a lot of extra equipment if you don't have the product to support it. You need to be able to get the acreage and the
Exactly.
product before you invest those
But at the
resources.
same token, you cannot estimate the number of trucks you would be using then if you have no idea if a rail is going to be available or not.
Well, that's a proposed, I mean, cap here.
100 trucks is
The 100
maximum.
The 100 trucks is a maximum.
A maximum if there's no rail.
You know, and again, that's one of those, we're putting these proposed standards and conditions in here to be conditions to hold us to this. So it's not a do whatever you want. It's you said 100 round trips per day. We're going to hold you to that, and that's going to be a permit condition.
But now that's something, how do you control and how do we enforce it? I mean, you're coming up with some conditions, just, we're gonna do this sound thing, but there's no penalty or anything, we're just gonna do it. You know, you're gonna stay at 55 decibel. Okay, who's gonna come out? What's the penalty if you go over?
Well, the potential penalty is you revoke the permit if it's a condition. And that's what we've asked for, is that this be placed as a condition, as an enforceable condition. I mean, I'm not your zoning administrator, but if a condition's violated, I'm sure he'll say there's the potential for it to be revoked, or it will get revoked, but.
But we don't have a sound meter to measure decibels either.
Yeah, so we don't. Yeah.
So, here's, the way to potentially resolve that issue, right? So there's a question, how do you enforce it? Well, if a residence isn't going to, the nearest residence, for example, isn't going to allow a sound meter on their property, and maybe we put one right at the property board. Haven't talked to the client about, but that just seems like a reasonable thing that it's added. Whether noise becomes an issue or, it's one of those conditions.
Go ahead, Doug.
As long as we're talking noise, I'd like to follow up with, several times you've told us that you won't go over 55 decibels. And also the fact that that's less than additional. So that in my reading here, all this information, there's been some question about his expert. So I'm not a computer wizard. In fact, I'm very low on the computer scale. But I Googled a crusher, hard rock crusher, and it runs at over 95 decibels to 100.
Yep.
I also Googled the screening process. That runs at 100 to 110. Then you talk about blasting, and that runs at 100 approximately. So how can you say that you're going to run this mine at 55 decibels or less? How do you justify that?
That's a good question. And we're putting in that 55 decibel requirement at residences where the noise could actually be potentially impactful, right?
Well,
So-
wait a minute, no, that's not true, because you Google the home distance from a hard rock mine. And a quarter mile is the highest, is affected the highest of all, then it goes down out to a mile. Because there was a study, there's been studies on that too. So how can you say this first group of 100 of a quarter mile, which is I think 20 homes, is not going to be affected because you're saying we'll test this after the fact? I mean, it's been said that you're going to put this behind the wall of the mine, but that's not going to happen for 3 years. So you're going to have all this noise on the surface.
Keep in mind that you're right on those numbers. It's very loud, right at the equipment. The farther away you go from the equipment distance, there's a dramatic drop in the decibel level. And a berm drops it even more. So, we didn't pick that 55 just because it was a nice number. I mean, we could have said 60, 65 and still been within reasonable noise compared to pretty much anywhere in the United States that has sound limits. But we said 55 because we believe we can be at 55 or less based on the berm, the terrain, and the distance. And, I was pointed out, if we can't hit that level, I'll get a call from Jason that says, fix it or shut it down. So that number was pretty carefully looked at as to what that noise level would be. And our biggest concern, obviously, is the Wallace Fountain. They were 800 feet away from us, from the Kramer Quarry, and we shifted everything south. So we increased the distance 50%. And that distance increase helps us on the sound levels. The deeper you go with the quarry, the quieter they get. But because of the Lotus Lake thing, we didn't have that opportunity. So we had to factor that in, that you're only 10 feet deep. You're going to lose that benefit. So that 55 is kind of a hard number. And it's a number that we've agreed to live with. And if there needs to be permanent or semi-permanent measurements put in place at the close by residences, do that. Do that. It shouldn't be an expense for a homeowner to run outside with their cell phone and hold it up to see what the decibels are. So I think the 55 is doable, not easy, but doable. And we've agreed that that's a self-imposed condition. Many of these conditions are not part of the permit process. They're part of the process that we imposed on ourselves to mitigate some of the concerns. The sound, the trucks, and the impact potential on Lotus Lake and area wells were our three biggest concerns. So when we came back with this permit, those are the three areas that we wanted to make sure that we could address. So anyways, that's the story on 55 decibels.
As long as you mentioned trucks, I'll go back to the second question I was going to ask. Just was said about a few minutes ago by the chair that you were talking about 100 truck trips a day. Are you going to just shut off the trucks, close the gate when you get to 100 trucks? I mean, how is that even doable?
That's exactly what we would do. If it's part of our permit that it's 100 trucks a day, and we have 50 trucks coming in, and we know that 50 trucks are going to be coming back, that's the limit. We don't want to lose our permit based on a few trucks. So again, that's a self-imposed condition that I believe we can monitor. And I know we can monitor too what direction those trucks take when they leave the quarry. I've talked to the other folks here in our group, and if we direct a truck that you take double M to M, Osceola to get across, or you take a right and go County Road F, 65, Highway 8 and across, that's the mandate. We see a truck turning right that should have turned left, that truck probably won't be allowed in the quarry again. I mean, these are strict rules. Same thing with backup alarms. We can force backup alarms on our equipment. It's harder to enforce on a private truck, but you mitigate that by eliminating trucks that have to back up. You circular loading where there is no backup. Okay? Or you assign a person. That's another mitigation. If you have a person on the ground with the truck driver as a safety protection, that's an alternative to backup alarms. But I hate backup beepers. I hear them all the time where I work. And that's why the white sound elements came out. I think you're going to see more and more trucks that go with that. We can require that on our equipment, but we can't require it on trucks, private trucks that are operating. But we can certainly lessen, if not eliminate it, by the way we load trucks, the way trucks come in and trucks leave, that they don't have to back up.
Go back to one more about the noise. So now you set up your crusher, everything, it's at 110, it's at the 100. You can't mitigate it. You just spent $2 million on all this stuff and we shut you down. Same difference as not doing the studies ahead of time, is it not?
I'm sorry, Kim, what's
The question is,
Try the question.
so now you spend all this money, you put the crusher in and you can't beat the sound. What do you do? And we shut you down. Now what do you do?
I guess we're shut down, aren't we?
But I mean, you don't want to spend for a study ahead of time, but you'll take that chance, buy all the equipment, set everything up. Now you can't get it to meet that sound level. What do you do then?
I'll shake the dice and say my odds are better that I can meet that sound level than my odds of somewhere along the way getting crossways with a report or mitigation or reclamation that doesn't work. I have no control over that. I mean, it is what it is, and I submit it. And if it falls short of the standards, well, you know, we're done. But the sound, that's all on me. What I can do to mitigate that sound. I was reading a sound report out of England. You think we have noise restrictions here? They go as far as lining their rail cars with a rubber underlayment to cut the noise. And the same thing with trucks and using soundproofing around crushing equipment. I mean, they do some serious stuff. And it's, you know, if you've been to England, it's a small country and there is no hundreds of acres of buffer around a quarry there. They're right next door to everybody. So, but there's a lot that can be done, but we would control that. So if we say 55 and, you know, it's like set a 65, and I get the call from Jason, we're going to either correct it or we'll have to stop. We'll have to change our business practice.
Go ahead.
So 3 to 6 blasts a year you're talking. How many blasts each time? I mean, is it just one blast 3 to 6 times a year? Is it 10 blasts at a time, you know, every day, 3 to 6 times a year?
Yeah.
How many blasts per blasting session?
If you were like Cindy at Abramson's and listened, you'd say that was a blast. But I'll guarantee you there might have been tens, if not 100 microblasts. You ever seen them where they take a big building down, a skyscraper, and it falls perfectly on its footprint? That's because of amazing number of blasts and where they're located, microseconds apart. So in answer to your question, if you were there, you'd say that was a blast, one blast. But in reality, it could be 50 because they're microseconds apart.
In one condensed period of time, I think is what, not 50, you know, 1 minute apart. I think that, you know, we just want to clarify that.
Nope.
That was a small blast in a very condensed time frame would be one blast.
Just so something that was asked at one point from the public, I guess. Because it is trap rock, and you're gonna have a 16-foot high berm. Where's the material for the berm gonna come from? I mean, it'll have to be trucked in.
Yeah, that's correct. We will have to truck some of it in. We do have a open field zone commercial that adjoins our property, also owned by some of the property owners that own Blue Rock. There's material available there. Prologan typically wants dirt, build their ski hills up. We want dirt too. So that would be, you know, part of the operation plan. You have to keep in mind that, you know, if you said today, yes, Glenn, you get the Polk County permit. Good luck with it. And all the other stuff that has to be acquired and the berms that need to be built and the equipment, you know, Anders alluded to shovel ready. I'm going to guess on this. I'm going to say 3 years minimum before you see any rock leaving that place. Because there's so much work that you have to do. The biggest blasting concern is first, I don't know, perhaps a year, where we need the level area. We have a lot of rock where we'd like to process. You could say we have too much rock. Well, we have rocks sometimes in the bad, wrong place. and we need to remove those rocks to create some level area. So that removal of that rock will happen, probably, I'm guessing maybe year 2, okay? Get a level area out. Otherwise, we've got to process somewhere else where there's level ground. But processing takes up a fair amount of space. So just to give you an idea of the time frame on it, probably 3 years. And that was a number even Kramer with their larger operation, unlimited funds and ready equipment. They kind of said that too, 3 to 5 years before they would get up to speed. First rock within, say, 3 years. So it does take a while.
Now, in what you just said, and you're talking blasting, building this berm. So are you gonna start blasting before the berm is even up in this 3 years? Level, so you have a place to put the product?
That would be nice if we did that, but I'm sure that Mr. Wallace would call up Jason and say, hey, they're over 55. So no, the berm has to be built before there's any blasting, crushing, or anything. Unless, there's just no way around that. That berm has to be built. Keep in mind that, I'm not as close to the quarry as some of the folks in this room are, but I'm not a terrible distance away. When the Haas quarry was activating and running 24/7, okay, 7 days a week with their crusher, no blasting, we couldn't open the windows in our house at night. The noise was, the crushing sound was just intense. Well, I know what crushing sound is, and I know I don't like it. I know none of you would like it if it's next door. That's why the berms and the mitigation effort is so important to us, because I don't want to hear that sound either.
But you just keep talking about it being so low, but you just talked about Haas being so high, it was affecting you with your windows open. So it's not gonna affect these citizens, but it affected you. And from Haas, you're not gonna affect these citizens.
Haas had zero mitigation, okay? They were there. When I grew up on that farm, that quarry was there and they were operating. They've never had to meet any restrictions.
You're gonna burn 4 sides.
We're going to burn wherever the noise exceeds 55. Yes.
You're gonna wait to find that out after the fact.
No, we better find it out before the fact.
So now another question is, who's gonna be the operator of this pit?
I know.
So we don't know who that is, so we don't know if they can be bonded, if they've done other places, bad, good, in between. Isn't that part of some of this stuff too, that we have to know that?
So the bonding requirement is a requirement of the reclamation permit. And with that, when that comes in, that's where the operator, is identified, and the owner of the land has to certify that they agree with the reclamation plan. And that's where you've got the bond or the irrevocable letter of credit or the cash to ensure reclamation occurs.
And it's a reputable operator that they,
Absolutely.
I mean, how do we?
Yeah, exactly. And that's where the state statute and NR 135 has said, you're not allowed to move dirt until you've put in the bond to ensure that you can meet your obligations. So that goes to gain the reputable operator there.
No, they,
Yeah.
but the ones I had have been for the most part asked in one form or another. Oh, that's
So, about Sharon.
Mr. O'Connell, if I could, just to follow up on that, maybe I didn't make myself real clear. The Haas quarry that we were hearing, they were at a high elevation, no berms, okay? No sound controls or anything. Our house is at a high elevation, okay? And I remember I asked Dan Birch one time, how on earth do you tolerate that noise? I mean, he's like 100 feet from where some of this is happening. And Dan says the noise goes right over. So line of sight and direct line is a major factor. And we got a ton of noise off that. But that was because Oz was high and we were high. The noise in the valley was less. So I can't predict, where the, how the sounds will be, but I know that our operation does use Burming, and we are not at a high point. We are kind of at a low point where the processing crushing would take place. So I don't know if that gives a little more background on the Haas quarry noise. Yeah.
Will crushing happen every day then? Would crushing happen every day?
I'd really need to ask the operator that question. I don't know how much they stockpile, and I'm not even sure how often White Way or Dresser Trap Rock crush. They crush every day. I know don't hear it every day, but I don't know. It could happen every day. It could happen twice a week.
Because crushing is pretty loud too.
Right, that 55 decibels, the crushing will be the harder to me, not the blasting. It's the crushing and the screening.
And that's, again, that's why you're proposing to build up the berms around the processing site and to mitigate it that way. And I think, if there's a concern about, it's not 24/7 crushing, there's, we have the hours that are proposed as limits on operations total. So that's trucking, the mining activity, processing. So if that is, a concern about crushing starting earlier in the morning, maybe that can be one of those permit conditions where you say, okay, from 10 a.m. to 4 p.m., it's limited to crushing. Or, crushing's limited to those windows. Whereas trucking can also continue as any business could be able to truck during the normal hours of operation.
But in reality, if it meets 55, it's like a dishwasher, nobody should hear anything.
Right.
But that's not the case with Dresser. You can hear Dresser. I was just on a golf course in St. Croix yesterday, and I could hear the crusher going on Dresser, and that's at least a mile away. I mean, it's loud and clear. So if, I don't know what decibels they have to meet, if any, but
I'm not aware of Dresser having a decibel limit in place on their permit. Is that, anyone that disagrees with that?
That's not us, yeah.
and then the plan is still to use the high capacity well at Trollhagen for water. That's what it says in this.
No, that's correct. Obviously, we'd be able to get some water from runoff water, et cetera. Dresser Trap Rock has no well. They process an immense amount of rock, and all their water is coming from either surface water or runoff water. I'm not terribly sure. So we have that option too, but I believe the majority of our water could well come from Trollhagen's high capacity well.
The access to get on double M, you're going through somebody else's property and getting on double M and then F also, have you talked to the county about permits? They needed extra lanes or anything, if that has to be done also?
We control all the property for either access point. And the county highway department signed off on County Road F. Now this was back in the day. We'd have to ask them, has anything changed significantly that you want to rethink that?
What do you mean by signed off? What does that mean, signed off?
Polk County Highway Department said there would be no issues with a access road coming on the County Road F.
And this was from the previous application?
Yes. So traffic might have changed. We'd have to ask them again. Our preference really, and I think it's the county preference too, Highway Department, is to access on the double M. The visual range on double M is far better than County Road F. So if they were kind of okay with County Road F back then, we think that they would be even more okay with double M today because of where it would be located.
So then most trucks would go double M to M to 65 to 8?
No, it kind of depends on where they're going. I mean, I see trucks, we get a ton of truck traffic going past, our home on double M. Some of that traffic is headed down to Iowa. Okay. So it kind of depends where the truck is going. If you're trying to get into Minnesota, you can do double M to M through Osceola across the bridge, or you can do double M to F and State Street and pick up 35 in Dresser. Or you can go, you say, we really want to get off town roads, okay? The other entrance would be County Road F to 65, perhaps County Road Y would take you to Highway 8. 65 would take you to 8. 65 would also take you down through New Richmond. So there's a lot of different ways to go. But the idea is to keep all the traffic on state county highways that are suitably rated for truck traffic.
So this was a letter signed by you in February of 22. It states on home values, we can provide an independent insurance policy to protect your home value at no charge to you. Your house will not lose value should you ever sell. That's, I'm assuming, come from you, so I'm assuming that's something that you would be willing to.
Yeah, it's not for the whole county. I think is there a half mile or something it says? Or adjoining property?
How about Clam Falls?
Just one township. Yeah.
Being that you're on the committee, I'll consider Clam Falls.
There you go.
Yeah, no, I think it's, I think there was a distance on it.
Okay, it
Either
doesn't, at
adjoining-
least if it is, I'm missing it. But okay.
It was either adjoining property owners or within a quarter mile. I thought that there was a distance on it that was reasonable. And yeah, that's correct. You basically have if you go to sell your property, you're going to have an appraiser come out and say, okay, your house is worth 200,000. And if that appraiser says, oh, by the way, with that quarry half mile away, I don't think you can get 150 for it. This insurance would cover that. If there's a recognized loss value by a reputable assessor on your property, that's lowering the value of the property. And believe it or not, that insurance is fairly inexpensive because it very rarely happens. The town of Osceola's own assessor, when he was asked, will this devalue my property? And he said, your property would go up in value, could go down, don't know. But he certainly didn't say that it would just automatically diminish the value of the property. And he did say, yeah, it could go up in value.
Excess water noise. What else do we have here? More questions in? Jason, did you have anything more to add after this?
Just to clarify the record, the comparison table that was provided at the June 1st hearing, I would like to make exhibit 75. And then I'm going to request a copy of the slides that the applicant did for the rebuttal, and that'll be exhibit 76. We have a clear record. There's been numerous mentions of how there was an existing mine on the property. And I just want to be clear as far as what role that plays in this application. Anytime you have a use on the property that changes and no longer complies with the current ordinance, it's considered a non-conforming use as long as it was legal when it started. So back in the 20s and 30s, when this was being mined, there was no zoning at that time. So it was obviously an illegal use. That, however, once that operation quit operating for 1 year, their non-conforming or their grandfather use provision no longer applies. So this is to be treated as a completely new application because of that. I've heard both sides, and I'm not going to debate. That's not my position. But there's been the argument that this is a totally new application, but yet the committee has also been told to look back at some of those 2009 studies. And that's where I think that the comparison table, as exhibit 75, breaks down all the tests in that have been done. I think some of them tests are related to the size of the operation that was proposed back then. I think some of them are related to the physical characteristics of the property, like groundwater depth and that location and that to, homes, proximities, noise, there's a lot of stuff like that. Hydrology, hydrologic, all that can be different. And that maybe in some, if you're looking at two different properties, but this is the same. So I think some of these studies are relevant to what I'm saying. Act 67 is brought up, and they've been brought up several times. I agree with both, arguments that have been made that if a county and that has substantial evidence and that to be able to grant an application that the committee would have to do. And it is the duty of the applicant to provide those facts and information as substantial evidence in order for you guys to make your determination. I think it's also important to know that the county has updated their code of ordinances for Act 67. We have the definition of substantial evidence in there, and we've got the relevant language. So the ordinance is up to date. With that, I think we can pull up so section 42-149 is providing, parentheses C, provides the standards applicable to the conditional use. This is very important for the committee to consider because these are the criteria that you need to take and deem the application is complete on. And two, if it's going to be granted, that it meets these criteria. So I'm not going to read them, but you can see we got maintenance of safe and healthful conditions. Noise is definitely in there. Orders, heavy equipment, water pollution, sedimentation, topple, erosion, a lot of the same stuff that you've heard. Subsection D states that a committee can take and assess conditions, like we've seen from the applicant, periods of operation, landscaping, planting trees, sewage, setbacks, yards, all that kind of stuff. Sureties, bonding, deeds, it goes on. Basically anything that you guys think are needed on the application to satisfy 1 through 12 as conditions, you can imply as a condition. Subsection E says that the committee can request additional information like 1 through 5 here, and that in order to be able to make your determination. So if the committee and that is feeling like they are lacking information to know whether or not any of those 12 criteria are met up in the front, this 1 through 5 here will allow the committee the authority to seek that information from the applicant. And again, back to Act 67, and that it is the applicant's duty to provide the substantial evidence in order to take and make your determination. So with that, I think,
Is this gonna be long?
what's that?
Do we need our dinner break here? How long is yours?
Short.
Short, keep going then.
Oh, with that, I believe in that what we heard from Attorney Vivian this morning is true. Some of these studies on this comparison table are land specific, some are operational specific. I believe that the operational specific plans and that probably need to be updated in order to be able to provide enough substantial evidence to the committee to be able to make reasonable conditions that would be deemed reasonable by a reasonable person, is what Act 67 states. And so with that, I think the committee could determine that the application is incomplete because that information has not been provided. And so those determinations cannot be made to have reasonable conditions. Or I think you could take and postpone the application indefinitely, looking for the facts and information that would create that substantial evidence record for the proposed use. Because again, the application as submitted refers to the 2009 studies, but yet thinks that it's substantially different because of the size. And that's kind of laid out in this comparison table. So if we don't know what the impacts of that size change are to make it substantial, and that, how do we know what the conditions could be or the impacts could be? Some of the things in that kind of are interesting when reviewing the file and in my staff report on the first, the water table of the 09 application was determined between 80 and 81 feet down. And that the current proposal, and that says that they won't go any lower than the Lotus Lake elevation. Lotus Lake is at 958 feet above sea level. The highest point on the property is around 1,100 or just shy. So that means that you could end up going down and at 142 feet. Okay, now there's that groundwater divide that we heard, and we've got groundwater between 960 and 990 feet, depending on where they're at. So if we're going to 958, there is a possibility in that there could be some mining into the water table, which is one of our conditions here about, you know, the prevention and control of water pollution is number 3. So that's something to look at. Access to County Road M. The applicant just said that they have access going out to County Road M currently. Rockford Incorporated does own the parcel between County Road M and the railroad bed that's there. However, and that the railroad does own a 100-foot wide strip there that they would have to cross in order to get to the proposed quarry location. So staff would recommend that that is approved by the railroad, it's still private property, and that they're a different use than just crossing it for walking purposes or whatever. And it is 100 feet in width. So if you're moving that kind of material, you know, is it going to be a conveyor going overhead? Are they going to approve of that? Is it just going to be a drive over access? You know, I think that needs to be clear because that could take and change the amount of traffic that goes on M to actual County Road F. So it would have an impact. The access plan and the use of the railroad, I think that's been kind of the ghost in the room, if you will. There hasn't been a lot of information on that. We haven't seen anything from the railroad. We know that there's tracks out there right now, but they're in a pretty poor state, and that they're not able to be used. So that's something in that I think the committee could require. 2006 was the last traffic study, and that was the traffic study that was used in the 2009 application. Here's an operational change. So if we go from 400 trucks a day down to 100 trucks a day, and that's definitely a change that I think could be sought by the committee to see if that impact is going to be the same. Over the last 16 years, there's a lot more traffic in the county. And there has been improvements and changes in roads with roundabouts and turn lanes and all of that. So the 2009 application had a reclamation plan and a reclamation cost. Obviously, that was on a 60-acre site and a 23-acre processing facility. This is going to be much smaller scale. In order to be able to do a good job creating the plan and to know what kind of bonding could be required by the committee, we would need to know what is a reasonable number. It's been brought up several times about having the scale drawings and having an accurate layout of what the site would look like. I think that's fairly easy for the applicant to provide. Because that might bring up other concerns, or it may solve a lot of the questions that have been asked. The sound study, what that was done was very inconclusive, I'll say, when they did it back in 2009. And when you have something like that, or these berms, it's been brought up by the committee about how are you going to know if it's over 55 decibels until afterwards, as far as where you create berms on the property. And so a sound study like this, or some traveling, and that as far as the noise, and that simply even going out there and recreating that noise temporary here and measuring it at some of the households around, and that maybe would determine that no, that we actually need it at 65 in order to be able to operate underneath our permitted allowance. So the study and the old application that did find a cacti that was underneath the national plant list for the state of Wisconsin here, that they was supposed to be relocated at that time. I think in that being that was done 18 years ago, the new study and that could be justified to see if that plant came back, and if it is, how can we relocate that out of the area so it's not affected. Well, usage is hit upon here a little bit, and that with Trollhagen, and that providing the total water usage. But what is that usage? How many gallons a day are we talking? And is that going to affect the groundwater? I think the operator is a reasonable thing to ask, or at least to have a point of contact. Because if I've got a complaint on a 55 decibel noise limit, who do I go to for that? Right now, Dresser Trap Rock, I have no idea who I would contact, as far as if I need to take and resolve something that day. So I think that's maybe just, having the property owners take a little responsibility, and being that main point of contact may satisfy that, but it's still, and that usually to have a point of contact. And we've got that condition in that for our CAFOs, and we've done it on other applications where they got to provide a 24-hour contact number. So no, there isn't anything really new there. Stormwater management, we have that unnamed creek up on the northwest corner of the property. We don't know on that if there's going to be water going that way at all from any of the sites. So that could be something that could be solved by having that stormwater management plan. Maybe those basins that they were talking about in their applications, that could be looked at, as that being from surface water just running there? Is there any erosion, that kind of stuff? Which goes into the erosion control plan as well. So those two could be one and the same almost. There was several public comments in regards to this. Zoning is a very local authority. The town of Osceola has a comprehensive plan. It's Exhibit 5 in the record. They've decided what they want their land use to be. The town of Osceola has a public nuisance ordinance where they do talk about noise. The town of Osceola also has a non-metallic mining licensing process and that to go through, similar to a reclamation plan or a health department license and that to go through. So I think that the town, being that they've got a comprehensive plan, and in 2017, the town of Osceola entered into a cooperative boundary agreement with the village of Dresser for extraterritorial zoning. And that's where I think the village of Dresser and that input needs to be received as well, because they've got ordinances as well, just like the town, and how all those ordinances work together with the county's ordinances. Because we might create a bunch of conditions that maybe are already covered by their ordinance, or they may say, well, our ordinance doesn't cover this, we'd like to have this as a condition. So I think, whether or not, people wanted to go back there, unfortunately, and that local control, and that is very important through the zoning side of things, so that they have their input. And they are the elected officials in that for their municipality. So with those conditions, and that's where we would recommend postponing until the applicant can come up with that information.
All right. Okay. You still get rebuttal? Yes, you do.
Just add a few points. Maybe that's the famous last words from an attorney to say a few points. But, just to kind of working backwards from these items, in terms of the village of Dresser's consideration here, I respectfully think the extraterritorial zoning statement is incorrect. That cooperative boundary agreement specifically applies to these growth areas that were highlighted in that agreement in the town of Osceola. And then within the agreement, it says, and the proposed mine here is not within those proposed growth areas of Dresser. And section 11.01 of the cooperative agreement says that any areas outside of the village growth area are governed by the town if they have a zoning ordinance or the county ordinance. And this is outside of these quote unquote village growth areas. And I think I have the agreement with me and I can show it to the committee, but I respectfully saying the village of Dresser has any zoning authority here is incorrect under section 11.01 of the cooperative agreement. And again, and if they had zoning authority, we'd be at the village of Dresser, not before this committee. If you need me to pull that up, or maybe I'm missing a different agreement or ETZ ordinance, maybe I'm wrong on that, but I think
Well, if they don't cover it, that's fine.
yeah.
But we still would want.
They do have a wellhead protection area, and they do have other resources, including their roads, and that can be impacted, and that because the main truck route was to go through County Road F to hit 35 and then go north to Highway 8 or go south to 243 in Osceola as part of the traffic study that was completed in 2006. And that, so while they might not have zoning authority, the village of Dresser will have an impact, or will be impacted possibly by the truck traffic.
And what I heard from you was that Dresser has zoning impact here, and they don't.
It doesn't
And
say and that we're looking for their zoning approval. It says in that we're looking for their consideration and input on the application.
I know, but the statement was there's zoning that applies here that Dresser needs to have input on. In terms of other communities, are there any other uses that the committee ever says we need to go ask cities or villages outside our jurisdiction what their thoughts are? I mean, that's, you know, we just want to be treated fairly and equally like any other applicant. And that's, you know,
We did actually just have one, and that the Scott Lee pit and that north of Amory. And that is underneath extraterritorial zoning. We did notify the city and that for that process as well.
right, yeah, when ETZ applied, which again, it doesn't here, but in terms of the town of Osceola's consideration, they only decided not to say one way or the other whether they approve it. And there's a licensing ordinance where they ultimately do have that local control. So in terms of the other, you know, items raised here, again, a lot of these are items that you can put in as a permit condition that are subject to Jason's review and approval. So, you know, what Jason has just suggested is we can't come back to the committee until we basically spend 6 figures. Oh, wait.
No, go ahead, go ahead.
We can't come back to the
No, I'm
committee.
wondering if we should be letting you rebut this or not. We should be, probably shouldn't then, huh? All right. So in our normal hearing checklist here, you don't get to rebut these. How's that? Oh, you got to do something.
You request
These would be either condition or we can request these before we make a decision. So we can still do that.
Yeah, and I'd request those be a precondition to actually being able to break ground. Thank you.
These are just, and that what I've heard from reviewing the file, and from hearing what the actual public testify, and that as far as operational stuff that could change, and that due to the change in the scope of the project. So if it's a different application, I believe all of these things have changed. And that to create a substantial change in the application, which then all of these and that can be justified in order for you guys to determine the proper conditions if the request is to be granted.
Okay. So we're down to, if any of the committee has a question of Jason.
I guess the town and the village have had the opportunity to speak, right?
They were notified.
They were notified, I mean, and for whatever reason, they chose not to.
The town has an exhibit though. Because the town of Osceola has that letter exhibit, does it not?
Nope, we didn't receive anything from the town.
Why can't we receive one?
Not on behalf of the town.
Not on
Received-
behalf.
And
Okay.
then letters and that from town people, but not, as
Not
their
from
own
the-
comments, not cooperative.
But did they not vote at their last annual meeting to deny it? And we have that in the record.
Correct. We do
Okay.
have those
So
minutes
that's
from
all
the
we- that's all
annual
we have.
meeting.
Well,
Correct.
no,
Without
the
condition.
citizens took the vote, not the town board.
Okay. All
The
right.
citizens took the vote.
All right. Not
Now,
the
the
town board itself.
citizens took
Okay.
the vote.
Just to be, so we know that's.
Yeah, just to be clear, it wasn't the town board that said, no, we don't want it. It was the majority of the citizens that were at the
At
meeting.
the meeting. Okay.
Those annual meeting minutes are exhibit 12, just for the record.
Okay. So then it did. Okay. All right. So that. Did you have any more?
No, I think that was,
Make that clear. Okay. You're done? Doug, do you have anything more? Not for Jason. So you want to ask those now before, otherwise we'll close the public hearing.
Right, if you want to start debating, you want to end the public hearing.
And then,
Yeah, I want to debate, so
Yeah, so it might be a good idea
so
you,
with us, okay.
to end the public hearing.
Me, come on, give me a break.
so that's fine. I just don't want to get left out.
You're not, no.
So if you do take then a lunch break, I would remind the committee Don't discuss anything about the application at lunch. You can talk about anything else, grandkids, the weather, you know, but nothing related to the application.
But we can, so if we close it here at 12:30, then it's just down to our discussion, what we're gonna do.
Yes.
Okay, so that's where we're at then. So do
We're
I need
closing.
a
Yeah.
motion to close the public hearing?
Yes.
I would need a motion to close.
Make a motion to close.
I'll
Public
second it.
hearing.
I'll second it.
Second by Brad. All those in favor then say aye.
Aye.
Opposed? Okay, 12:31. All right, we will break for lunch. Let's take what, 45 minutes? And then we'll go into our discussion. So we left off with Jason. Do you want to put that back up there maybe for us, Jason? Your recommendations, Bob?
Yeah, right. Wait a minute.
Oh, you did? Okay, perfect. Thank you.
It was the last information that Jason gave us. So that was our, right here. So that was Jason's staff report. So now we have to decide. Do you want to ask some more questions, decide if we should ask for this information? Go with our staff or,
Doug, you were gonna say something, I think.
yeah,
You just started.
go ahead.
I guess what I see here, and I underline, understand the impact because we're sitting here at this use hearing, and Jason writes up there that we can go through back and start over, give it for ask more standing. Well, they've had all this time to get those things done. And if you go through the list, I've got 11 things here. Noise, blasting, traffic, water quality. We can discuss each in each one and the facts of it haven't been met or decided, or I can give you all my little.
So do you think we should do what he's asking, go back, postpone it to have these studies done? then?
No, I'm saying I
Not yet.
don't. No,
Okay,
they've had all this time to come up with these, and they put it back to 2008, 9, compared it to that. Now we want to ask them to come with more facts that I don't know at this time that we need. Myself, I don't. I have a list of facts here that goes on and on. We discuss homes, we discuss vibrations testing.
let's go right down to the list. Start with your list. Let's go
We can
down.
Start with noise, and I say.
Noise, yep.
They're telling us they can stay at 55 decibels, and there is just no way that can be. It's just made up figure. When you look at all the high 95 for a crusher, 100 and 110 for a screen, and they're going to be at ground level with just a berm, and that one study shows that there was in here that shows the vibration noise. They just aren't big dishwasher. Not in my, not what I've read. There was a study in Ghana that I read online that said all the quarter of a mile, 500 meters. That's your impact, highest impact here. And, you know, now they're saying, well, we can get it down to 55 in the dishwasher.
Point of order, just to clarify, I just heard that there was a Ghana study that's been brought into the record that I didn't hear. And I'm gonna just know that prejudices these proceedings.
Totally, I don't have a right to look on Google to compare to this.
As I admonished the committee at the first hearing, we're supposed to decide the application based solely on the evidence here at the public hearing. not to do any of your own independent research.
That was research was done before.
All right, I'd like that noted for the record as well, that research was done before our first hearing.
You looking at me like I did something wrong again.
I'm
You know,
going
I
to
don't know
admonish
how
the
I'm
committee,
supposed
they
to-
need to set aside any information they may have had prior to the application and base their decision solely upon the information and evidence
That
that
was
is
given to
presented
us.
at the hearing.
And we just have to acknowledge that. So then we go to blasting. Are you waiting for me to go?
Yes, let's go down your list. Let's do each of us has a
And
list.
there's the studies in here and the information we have that shows that there is no conclusive, inconclusive,
Inconclusive
yeah,
evidence.
evidence that it won't damage structures and foundations. Because they don't know, it could, because if you don't know, then it could damage. And blasting is back to 100 decibels. So we got another noise issue.
Was that part of that Ghana study too? I'm sorry to
No,
interject.
that was one comment on it. That's all. That's it. It was, had to do with 50 meters, 500 meters. That's all I learned. So that's wrong, then I'm wrong. Traffic, we go back to a 2006 study. They're saying they go from 400 trucks down to 100 trips. And I guess it's just, that's a fact. And I have trouble with that they're going to stay at 100 trucks. And another fact is that the applicant mentioned before when I asked him about the town road, because that's in here, one of these, it's in that packet. Then he said, well, we will not run trucks on the town road. Now today he said, really want to not run trucks on the town roads. Well, this all seems to be like, well, we don't want to do that, but that seems to be a fact. Water quality. Now we get into wells. And there is no study in here that ever comes up with a reason that it won't damage local wells. Because they're talking about fracturing, I think it was north to south, already found on this property. Then we go beyond water quality and we start talking about a reclamation plan. And they're saying, well, we can do a reclamation plan later, but there is some projections in this information that says that right now they were talking about the chance to either put in ledges or fill it with water and have a pond. And their answer to that is it will take up to 30 years to fill it with water. So it's like, that's not a reclamation plan to me. So in the vibration, you can't get away from the fact that there is going to be vibration, and they haven't done any testing on it at this point that I know of. And they talk about plants, and the only biological study was done 2000.
It was 6.
2006.
I think the plan.
But they also did it in the spring when you're supposed to, it's been said in there that you're supposed to do 2 studies in the summer because you want when the plants are beginning and when the plants are growing so that but that was never done. So that seems inconclusive to me. Then homes, there's a lot of talk about homes and prices and values. And the one interesting thing that I see in the studies is that they're putting a hard rock mine where all these homes are already established. But they talk about some growth in a major by a quarry where people moved in. Well, then I see it's exactly opposite because people are choosing to move next to that quarry, but these people did not choose to be next to the quarry. They built their homes thinking it's a nice quiet neighborhood. guys can elaborate on any of this you want. Then we talk about rail traffic, and at this point, it was brought up today that no one has talked to the railroad. So it's pretty hard to say, well, we're gonna use this with the railroads to lower the 100 trucks when you haven't even talked to the railroad to see if there's any chance, because Jason mentioned it today, the pictures he showed us, I thought the railway was in quite disarray. Then we talk about launch roads, and the last study was 2009, I wrote here. And there's a lot of change since then. And I think if you're gonna say, well, we have a approval from the highway department, having one back even 2000, I don't think that was really, I wrote down 2009, but I think it was for that on the roads, but approval. Then looking last, and we talk and worry about Lotus Lake and water quality, and we talk about drainage, and we talk about bricks. I don't think any of that has ever been really determined. I mean, there's no answer yet. And it seems to be quite a worry. And my looking at things and using the facts is we don't know the facts there. And once it happens, it's too late.
Okay,
I think I'll stop there.
you stop there. You feel these weren't addressed? What are we at? Tab 3, where they did most of these.
And 3.
And tab 1. Tab 1 and 3. Stormwater is tab 3, all right. I'm in this one, yeah. All right, Brad, what do you? I think everything Jason has got up there, with the exception of the town and the village. I think for the most part, I had on what I would have considered, moving forward, would have certainly been a condition if it was to be approved. The vast majority of them, I would say more. I think the noise, I don't know how they're gonna get to 55 decibels. I'm not sure. That's my business. That's theirs. They're the ones who have put that on themselves to get there. So if you want to go spend X amount of dollars, whatever it is, and Jason gets the phone call that says they're at 65 decibels, it ain't mine $2 million, it's somebody else's. So I think they've put the onus on themselves to get there. If they can or not, that's up to them. Yeah, I agree. If I just go through Doug's list, the traffic study, I mean, it's 16 years old. It needs to be redone. Having said that, 50 trucks a day round trip, or 100 trucks a day. I would dare say that in the last 18 years, traffic has increased considerably more than that on those same roads by homeowners moving in. And more people moving to the area, recreating to the area. So I don't see, as long as the traffic study is done, I don't see traffic as an issue. We've heard a lot about emergency services not getting through because of those trucks. Behind a dump truck or a car or a pickup or a semi. It's pretty much all the same to me. But yeah, reclamation plan. There's none there. There's no vibration study. And there again, the railroads, yeah, but I think that's also if it comes later down the road, I don't think there's anything saying that it has to come. So.
Out there too, okay. So I'm looking at the noise too, that way, I don't think it's gonna, but the groundwater one, I think we need something, a little better study on the, for the ponds in that intermittent stream. Otherwise, it's just about, like you said, the town of Osceola's consideration and village could come off of there, but I think we have to have the traffic and a couple of those studies, and we should have the study. It is affected on the groundwater. It is on there. I think we should, and an operator. I always thought we should have to know who the operators are, because if they're competent or not. I mean, that was part of the other one too.
Yeah.
We wanted the competent for bonding and stuff. And this is all part of that too, I think, so that we can do some bonding and go that way. So I'm looking that way. So Sharon.
Well, I can go through the list. I continue to be concerned about the railroad and the fact we know nothing about the railroad, whether that's even an option. And we don't know, like Jason pointed out, if that railroad owns that 100-foot wide strip. If nobody's talked to the railroad, how do you know you're going to get the access? And the traffic study, I noted that again because there have to be a lot more cars given the growth in the number of houses in that area. And again, the same with the sound thing. There is how anybody, and it's not like you said, it's their choice. They picked that number, but I can tell you, I've heard trap rock and yesterday on the golf course. It's not a dishwasher noise. And I was a mile away. And I think I'd be concerned about the well usage. How many gallons is that well at Trap Rock capable of? And I mean, we don't have any troll hogging. I mean, we don't have any information on that. And I know it was said Trap Rock doesn't have a well. I don't really know that. There was no facts given to us. It's just somebody saying Trap Rock doesn't have a well. I don't know that. If they have a well and what kind of well they have, how much usage they go through, given the tonnage they mine, I don't know that. And who the operator is, I think, is a huge deal. And then in updating your mitigation plans, the erosion control plan is a huge deal. When we do every one of these that we come through here for gravel pits or whatever, we have plans. We have plans in place to share with us, and it helps us make those decisions when we have those plans. So I'm concerned about that because we have a lot of, we're going to do that, but we don't have anything that says when, how, who's going to do those studies. It's hard to make a decision to say go ahead when we don't have the facts. And so I'm concerned about it. And I don't discount the village addresser because some of these plans will have these trucks going through on roads in the village addresser. What do the people in the village addresser think about that? I think that should be considered too. Just like the town of Osceola their input should be considered too. And I'm not saying anything about their zoning or anything. It's just being a considerate neighbor. And I would like to know that if I lived in that area, I would like to know that my town or my village had a say, or at least could express their concerns or opinions. And then I go back with what you said. There hasn't been a mine there for 100 years. 100 years. So these people that have built houses in the last 100 years did not anticipate there was going to be a mine. So I think that needs to be taken into consideration, because if I just spent money to build my dream home in an area and all of a sudden I hear a mine is going to go in next, close to my house. I mean, that's a quarter of a mile away. That's not that far when you're talking water quality, noise, pollution, but it's something to consider. We need to know more about that and what it's going to do to that area if this gets approved.
So give our reasons. Do we want to take staff's recommendation, postpone to get this to finish moving on?
I make a recommendation that we take staff's recommendation. I make a motion to take staff's recommendation to postpone and get more of these things completed.
Would that be a continuation of the
Of the deliberation.
you have to reopen the public hearing if you're going to take additional evidence.
Yes. That we would have another public hearing with this, and you're going with his list
Yes.
in your
Yeah, that's,
motion?
yep.
Okay. Yeah, so we'd have to have another public hearing after this information is out and publicized.
So would it be just on this information?
Correct.
So it would be just on the information that would be gathered here?
Which is, yeah, that's exactly what I'm saying.
Yeah, no, I was just making sure. I'll second that.
Jason, you had a question?
Yep.
Mr. Chair, I
Yeah.
would also agree with Malia that anytime you have substantial evidence or new material brought forward that could be substantial in the application. But as far as noticing and that, we would like to take and see the committee recognize that we, upon receiving it, that we provide 2 weeks for people to review. And that in addition to the normal 2-week review, and that if possible, and that, so that, in other words, and that both sides could provide feedback. And that if there's other studies that maybe come from outside sources on the other side, that both those could come in and that to our office, we could take and disseminate all that information as public information so that both sides have a chance to take and review the other side's comments and new information prior to the hearing.
So, all right. Do we have to put that in the motion, do you think? Because it's not the normal, that we put an extra 2 weeks in there?
I think that's more of a procedural thing as far as how to process the motion. If you pick the date certain to continue and then allow that enough time to make sure that that notice can happen, I don't think it needs to be in the motion.
It's just something in that I've
Yeah.
received from both sides and that both sides
A lot of material.
want to be open and transparent and then have the opportunity to review the information before it comes back.
Okay. All right, so that'll be a procedure thing. So we're not really setting a date yet with this motion.
I do think you don't want to set the date now?
We'll end up scheduling the hearing anyways. We'll have to repost everything. So, and that it'd be a postpone.
It would be, the date certain would be dependent upon when we receive the information.
You don't want to give a deadline, I suppose? Is that what you're saying? Just in case
I
some of
don't
these
know how
take
we do.
longer? Okay.
I mean,
Because it takes a
It
while.
But
isn't
we'll
gonna
still
be-
just have to do that. Yeah, okay.
So we'll still have to publish and everything and send it out.
the date certain will be is when we get the information that we've asked for.
All right. You think that'll work, or should we
Yeah.
put like a 1-year thing on it, or 2-year, or 5, what?
It would make sense to put a deadline on providing the information so that it doesn't go on in perpetuity.
So say a year, a year? Is that
Yeah, that's what I
fair?
was gonna say.
Yeah.
I agree with that.
It's your motion,
Yeah.
your second. So
Yeah.
put it 1 year
1
on
year.
it. Okay. So the motion is to go with staff's recommendation to get this information back to us within a year then.
Yeah.
And then we would set the dates for a public hearing,
Or earlier if. we-
or earlier if it comes. All right. Well, then, all those in favor then say aye.
Aye.
Aye. Opposed?
Aye.
3-1. It will be postponed then until this information is brought to us. No, well, I think we have identified subject matters for the next agenda. So do we need that done, Bob?
No, sir, other than the fact that July 6th will be postponed to the 20th of July. So your next meeting is July 20th,
It's July 20th and we will,
regular standing committee agenda.
and then we'll have, as things happen, we'll have that done. All right. Now, oh, sure.
I make a motion to adjourn. What?
No, Doug was asking.
I just looked up the 6th this morning, so.
Oh, was canceled.
Yeah.
Okay, yeah,
Right.
all
I
right.
make a motion to adjourn.
I'll second that.
Second, all those in favor?
Aye.
Aye.
Yeah.